Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Bring the jury.
Hello, everyone. Happy Tuesday afternoon. We're back again. We did some bricks and minifigs body cams earlier, and now we're back to talk about the O'Keefe versus Karen Reed wrongful death lawsuit and pick up where we left off. Not last week, but the week before, because I didn't have power
It's
last
been a
week.
while.
So it has been a while. It was not planned, was not fun,
I
but
don't think you did it on purpose. You just wanted a break.
I wish that was the case. Have you ever seen llama during a break?
No.
It's awful. I'm
Mm-mm.
bored. I don't know what to do. I don't like it. But anyway, we're back here to talk more about this case and get us caught up. Because we left off, we're starting today on June 12th of this year, because a lot has happened. I also did during the break period organized and sorted and all of that for the Higgins Albert McCabe versus Karen Reed and Turtle Boy defamation lawsuit, which is what we will be covering next after we wrap this up. And woo boy. Oh boy, is that one going to be fun, by the way. I haven't even told you about it. It's something. There's possibility of a lot of role playing if we want to.
Oh,
So that's fun.
love
It's a
good
little
role play.
bit. Yeah. All right. Where's my little banner for today? There we go. Be sure to like, comment if you're a replay crew, subscribe, hit the notification bell, please, and thank you for Couch Court with Llama. We only need about a little over 200 people to finally get monetized. We can have memberships, super chats, fun emojis for you to use in chat, and you got to be different colors. We're not that far away. So if you can help us out by subscribing, that would be greatly appreciated. Like a lot. We got the watch hours, but we just need you to subscribe, please. And thank you. It's free. It's all free. And it's very nice and a great way to support us. Hello, Mary. Good morning or afternoon. Happy to see you again. And same with you, Rachel. Hello, hello, hello. All right. So we only have about an hour and a half today because of school. School for her, school shopping for me. So we're going to try to cram in as much as we can today, but we'll be back. I'll be back tomorrow to finish up, and same with Thursday. So hopefully we can wrap this case up by the end of this week, but we'll see. We'll see what happens. It's okay. There's no reason to rush, as I've learned. Covering this case, it's a crapshoot. Nothing groundbreaking is really going to happen. They're just going to get madder at each other, which is fun. We did have fun on our last Karen Reed streams watching all those hearings. Oh, with Diller. I haven't thought about that guy in a week. Oh, Diller. Anyway. All right. So the big topic that comes up in this wrongful death suit is now Colin Albert. For those of you that did not watch the trial, he is the nephew of Brian and Nicole Albert, who owned 34 Fairview. And the defense's, I don't want to say it was their theory. He only testified in the first trial. But so Colin, his testimony was something. He doesn't remember anything about that night. He was there, but he wasn't there. He said he had never been in a fight, yet he had really messed up knuckles as if one would expect to have if they were into a physical fight. To which she said, "Oh no, I just fell down on the ground and caught my fall on my
As you
knuckles."
do.
As one
As you
does.
do when you fall.
As one does. And he was
I
like,
don't think I've ever done that.
have never been in a fight. And Alan Jackson was like, "Oh, really? Because here are some of your super cringy internet videos where you're trying to act like a badass to some lacrosse team." Or what turns
Bang,
out,
bang.
yeah, he's been in fights and he likes to instigate fights. And one of the theories that was going around was that Colin tried to fight John. And that's what happened to John. That's a theory. All right. We don't know that to be entirely true, but that was kind of what was there. But anyway, his testimony is one of the most asinine. I think I couldn't believe it because we had a break watching the second trial, and you guys were like, "Oh my God, you need to go watch Colin Albert." And I was like, this kid is unbelievable. So he's coming back into this wrongful death lawsuit. Karen is, trying to get him subpoenaed and all of that because, they're trying to say, oh, Karen has this false narrative conspiracy theory that everybody in the house and the cops were conspiring to frame her, yada, 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 right? So they have tried to get Colin to come in for a subpoena to tell them what he knows. And as it's going in all of the other subpoenas they've given out, it turns out people are not really wanting to sit down for these subpoenas.
Can't imagine why.
I know, right? It's kind of weird, don't you think? Hmm.
Mm.
So this is all going to be about Colin Albert because all of a sudden a bunch of stuff gets filed and talked about regarding him. And you're about to find out why that is. So we got a lot of reading to do today.
Oh,
I don't think we'll be getting to the hearings because then there's about a total of an hour and a half of hearings about Colin. So this is a very big,
he must be
big,
very important to have
he
all
must,
these conversations.
right? So let's go ahead and get in. We're only reading parts of them because some of them are like repeated things we've already covered, like repeated documents that are thrown in with the documents. We don't need to go over those. We're only going to go over the main parts of these documents because the first one's 50 pages, the second one's 109 pages, and then 4 pages. They got a
Oh
lot to
my
say
goodness.
here. So, hi, Amos. So we are going to go ahead and get into it, starting with this first one, which is filed by Karen. It is her memorandum in support of a motion to compel Colin Albert to attend the depositions and produce documents because he is not doing that. And they've been talking to him for a while.
Hmm.
So let me extend that there so we can see. All right, so we're going to read the first 9 pages because I was like, I felt like this was better read than trying to summarize like I did the other ones because I know some of us have, or some of you have been watching the coverage without seeing the first trial. So this does provide a little bit more context into what we were describing to you about Colin. So that's why we're going to read it. And maybe if we have time soon, we'll watch his testimony. I had it scheduled for the week before, but now we're running kind of behind. So, all right. So, defendant Karen Reed respectfully requests that the court compel Colin Albert to attend deposition and produce responsive documents pursuant to a validly issued subpoena. As detailed in the attached emails, what were normal communications between counsel of a subpoenaing party, Ms. Reed, and non party witness Colin devolved into another episode of gamemanship. Unfortunately, the court now needs to step in. And yes, we will be reading those emails because, of course, we will. Let's see. So, here's the background facts of this. So, Colin Albert was at 34 Fairview Road the night John O'Keefe died. He had a history of violent tendencies, despite what he wants you to believe when he's on the stand. And specifically, he and Mr. O'Keefe had a series of prior disputes. On the night Mr. O'Keefe died at the house, Colin had been drinking alcohol with his friends. And that drinking party continued at the house late night. Now, Colin was underage for drinking, right? He was an adult.
Oh,
He was above
mhm.
18, but wasn't he underage?
That's a good question. I don't know how old he was that night at all.
Because wasn't it like Brian Jr.'s birthday? Didn't he just turn 21? I think he
I
was.
don't have the answers to any of those questions.
Yeah, I don't remember entirely myself how old he was at the time, but
I
feel
really
like
didn't. That was like the last thing I thought about, but because apparently everybody drinks and drives and does things they're not supposed to do, even the cops over
yeah,
there.
even in
So,
cops. That's right. They love driving shit face, is what we learned. The exact time Colin left the house is a heavily disputed fact in the case. Regardless, however, when Mr. O'Keefe arrived at the house around 12:30 a.m. on January 29th, 2022, the medical evidence demonstrates conclusively that he was beaten up, punched in the face, and knocked backwards, sustaining a fatal wound to the back of the head. In the immediate aftermath, those individuals in the house, referred to as house defendants in Ms. Reed's federal court action, attempted to cover up their role in Mr. O'Keefe's death. For Colin's part, he claims he left prior to Mr. O'Keefe's death and was picked up from the house by his best friend, Allie McCabe, and driven
Man,
straight home.
there's
That's
a lot
not.
of names that keep coming up that sound the same.
Mm-hmm.
McCabe's, the Alberts.
The Higgin. There's one Higgin. However, the timing of his arrival at home is inconsistent with when he claims he departed the house. Moreover, in a photograph taken shortly after January 29th, 2022, Colin has scabs on his knuckles of his dominant hand that one would expect to see as a result of a fist fight. Additionally, Colin is tightly connected both to the House defendants and the lead investigator for the Massachusetts State Police in the death of Mr. O'Keefe. Specifically, Colin is the nephew of Brian Albert, who owns the house. Allie McCabe is the daughter of House defendants Jennifer and Matthew McCabe, who were also at that house. Brian Albert and Jennifer and Matthew McCabe were all at the house when Mr. O'Keefe died. Colin was also close family friends with Michael Proctor, the conflicted and corrupt MSP investigator that refused to investigate the House defendants and attempted instead to pin it on the girl.
The shade.
Right? The conflicted and corrupt. That's better than disgraced former trooper, I think. Well, we can add those words to it too. Say them all, it's fine. Not only was Colin at Proctor's sister's wedding, he was in Proctor's sister's wedding party. Oh. Proctor's mother circulated a public Facebook post in October of 2019 declaring that Alberts are the Proctor's second family and
Aw.
includes a photo of Colin Albert and his parents. So, for those that did not watch the trials and don't know a lot about this, because I know there's quite a few of you, this is why people are why the idea of a cover up and a conspiracy, there are things I think that support it, or at least make it possible to be real. Like it's reasonable to come to this conclusion. It's not like, oh, well, maybe it's no. If hypothetically Colin did do this, then the adults would have some pretty good reasons to try to cover this up, right? So there's that. Now, among a mountain of evidence demonstrating that Proctor attempted to unlawfully protect those in the house, Proctor's written notes he took early in the investigation show he knew Colin was in the house that night. But when he prepared his official report, he omitted Colin's name to hide his involvement that night.
Hmm.
Now, despite being present at the house after midnight on January 29th, 2022, Colin was not interviewed by the Massachusetts State Police until July 18th, 2023, a whole year and a half after this incident,
That's
which
crazy.
that doesn't make any sense why that would happen. That's crazy. This is remember, this is the death of a police officer, right? Now,
Why would you
John
not be
O'Keefe
talking to everybody that was there? Even
Mhm.
if they didn't see anything, you still have to talk to
Exactly.
them.
Exactly. Now, in case you didn't know, John O'Keefe, though, was a Boston police officer. Brian Albert, the owner of the house, was Canton Police Department, right? The Canton police officer, Brian was.
I thought he was the Brian. I thought he was MSP. Maybe he's Canton. Yeah, well, No, he's a Boston cop. Yeah,
He's a Boston cop too. His brother Chris, right? Isn't he in the Canton PD? Because Michael's in Proctor's in
No.
MSP.
Chris was a selectman, I thought.
Okay, so Albert's a Boston cop. John was a Boston cop.
Higgins is
ATF.
ATF.
He's Fed cop. But I thought one of Brian's brothers was like a detective for Canton.
Possibly. I don't remember the
I don't
family
remember.
tree.
Either way, there's a lot of cop connections in this story too. So they're not going to go interview somebody involved in or could have been witness to the death of another officer, which is another reason why the story is very strange.
I need cheat sheets for all these people. It's been a few years.
It's been a while, right? Yeah. I feel like there was a detective that was I don't know. They're all interwoven together. So, where was I? In a report of the interview, Proctor writes that Colin was picked up shortly after midnight by Allie McCabe, revealing for the first time the presence of yet another witness. Allie and another vehicle, hers, outside the house that was never investigated. Despite this new information, Proctor failed to confirm Colin's statements by seizing his cell phone or Allie's or polling carrier records. He didn't bother looking into them at all. He just took Colin's word for it, or rather, took his father, Chris Albert's word for it. On September 1st, 2023, Trooper Yuri Buchnick authored a 6-sentence report stating that he had contacted Colin in an attempt to have him turn over text messages he had captured screenshots of between Allie McCabe and himself on January 29th, 2022. There is no report memorializing what prompted Buchnick to call Colin, how Buchnick had obtained Colin's phone number, or how he became aware that Colin was suddenly in possession of text message evidence. Kevin Albert, which is the brother of Brian Albert, was with the Canton PD. Okay. There's so many. There's so many. In his report, Buchnick goes on to say that he contacted Chris Albert because Chris, not Colin, was in possession of screenshots of Colin and Allie's text messages. These messages were shared by the Norfolk District Attorney's Office as mere cut and paste of screenshots of text into a PDF document. They contain no metadata to confirm their accuracy, nor is there any audit trail of when and how Chris Albert came into possession of Colin's messages. That's so weird, guys.
That seems to be a trend.
Mm-hmm. Now, these texts, their origins, and most importantly, their metadata, help prove the whereabouts of relevant witnesses on January 29th, as well as communications among the Alberts, Proctor, and Buchnick that are not otherwise memorialized. Not only did MSP investigators fail to seize Colin's phone, they failed to seize Chris Albert's or Allie McCabe's phones and merely relied on screenshots of supposed messages passed from witness to witness without any authentication. Massachusetts State Police would never, they would never do that. That's crazy talk. Oh, wait, they did that a lot. Data download from that Life 360 application on Jennifer McCabe's phone shows time-stamped notifications of Allie McCabe's arrival and departure from addresses throughout the early mornings of January 29th. Not only does the Life 360 data prove that Allie McCabe did not travel straight home after dropping off Colin, as she told Buchnick in an August 25th, 2023 interview. More importantly, the data shows no evidence of an arrival or a departure from 34 Fairview or Colin's house at any time on January 29th, almost as if she wasn't there. Right? Isn't that what that's implying?
It is.
Allie also could not tell MSP investigators how she knew Colin was at the house on January 29th, and no communication from Colin relaying his location to Allie is included in the screenshots of their text messages. For these reasons and more, Colin has relevant information about what happened the night of January 29th, 2022. His communications with the House defendants and others concerning Mr. O'Keefe's death and Proctor's investigation. Indeed, his role was so important to the Commonwealth that it called him as a witness in Ms. Reed's first criminal trial. Fair point. Then they say Ms. Reed's attorney served subpoena upon Colin and then attempted in good faith to narrow the scope of the subpoena after objection. Now, on February 11th, 2026, Ms. Reed's attorneys properly served a notice of taking depositions of Colin for April 29th. See that taking a notice of that. On April 21st, Ms. Reed's attorney was promptly served a subpoena, also promptly served a subpoena upon Colin. The subpoena required Colin to attend a deposition and bring with him documents related to the case. Specifically, the subpoena required production of documents in Colin's possession related to the MSP investigation, Ms. Reed's criminal and civil cases, and his communication with the MSP investigators, the House defendants, and others directly associated with the case. On April 27th, the attorneys who represent the House defendants identified that they were representing Colin and served a Rule 45 objection upon Ms. Reed's counsel, including objecting to the scope of the request for the production of documents, which everyone has done. Now, in this case, they're like, it's too vague. It's too open. We don't want to cooperate, even though we want justice done and have nothing to do with anything. No, we're not going to do it. Okay. Where was I? There was the scope. However, Colin's counsel did not claim the subpoena was ineffective. They just said, but we don't want to give all of it to you. You got to be more specific. That same day, April 27th, Ms. Reed's counsel requested a Superior Court Rule 9C conference relating to the objections, wrote that, quote, it makes sense to take Colin Albert's deposition after documents are produced, and agreed to reschedule the deposition so they could address the objection. Ms. Reed's counsel did not withdraw the subpoena or cancel the deposition, and Colin's counsel did not take the position that the subpoena was ineffective. Rather, on April 28th, counsel for Ms. Reed and Colin conducted a 9C conference to narrow the dispute concerning the request for documents. During that conference, Colin's counsel did not take the position that the subpoena was ineffective, nor did Ms. Reed's counsel withdraw the subpoena or cancel the deposition. But they did discuss the possibility of narrowing the scope of the subpoena. You know, his lawyers are not saying, she had nothing to do with this. We weren't even there then. Yada, yada, yada. Apparently, we'll read the emails because they are attached in here.
Oh, goody.
Yes. As a result of that conference, the very next day, April 29th, Ms. Reed's counsel provided a proposed narrowing of the subpoena's requested documents, specifically addressing the main concern, which was Colin's communication with his parents.
Oh.
Interesting. Specifically, Ms. Reed proposed to narrow that request to a 4-month period immediately following Mr. O'Keefe's death, and counsel asked for a response to the proposal. Oh, that is interesting. Asking for his text with his parents after John died. Interesting. You're behind on this case, so I'm looking more than it's a lot, girl. There are 4 civil cases. There's like a bazillion Turtle Boy ones. I spent all day Saturday or Thursday, Friday, and part of Saturday going through all of the documents and everything. It's a shit show, but that's okay. We are here to refresh all of our memories. So it's a lot. There's a lot going on with this. Everybody's suing everybody. Everybody's being shisty as hell. It's wild. All right, where was I? With his parents. Specifically, we did the 4-month period, sorry. Rather than respond in good faith, Collins' counsel began efforts to thwart the subpoena entirely. For 3 weeks, Collins' attorney entirely ignored Ms. Reed's April 29 request for a response to the narrowing of the subpoena. Ms. Reed's counsel then reached out again on May 19th, specifically asking for a response to the narrowing, the production of responsive documents, and deposition dates in June. Now, the judge is going to love all this, right? Why can't you guys just get along like normal lawyers? I don't understand. I'm sure this is all going to be Rosenberg's fault. I'm sure. Where was I? On May 20th, Collins' counsel wrote that Ms. Reed's proposed narrowing was still not appropriately scoped, but did not address which paragraphs, what documents would be produced, or any deposition dates. Collins' counsel did not take the position that the subpoena was ineffective. In response, on May 20th, Ms. Reed's counsel inquired about which paragraphs were not appropriately scoped and asked again for deposition dates in June. Why are they just getting along? They can always communicate by semaphore. Our favorite new word. Might as well, right, Lainey? At 10 p.m. on May 20th, Collins' counsel wrote that they had conducted a reasonable search, but that they were unwilling to produce any responsive documents. Okay. Worse, Collins' counsel stated for the first time that Colin would be out of town indefinitely after June 2nd and would only be available on May 28th and 29th. Again, notably, Collins' counsel did not take the position that the subpoena was ineffective. So all of a sudden, he's going to be out of town indefinitely.
That is such a weird way to put that.
Yeah. Yeah, it is. On May 21st, in response, Ms. Reed's counsel advised that he would be out of state on May 28th and 29th, and inquired about dates in June, why Colin couldn't come back for any dates in June, and why notice wasn't given before 10 p.m. on May 20th that Colin would suddenly be gone indefinitely. He also asked more questions about the reasonable search conducted for the documents and what responsive documents they had for each category that they were contending were unduly burdensome and overly broad. Colin's counsel did not respond on May 21st.
But they could just call each other on the phone. I mean, according to Murdahl's attorney, you could just
call
email them if you don't want to talk to each other.
They don't even want to email each other. They don't even want to do the can-to-can telephone. They're just like, nope, maybe Karen Reed's team is like a T-Rex, and if we just don't move and stay silent, they won't notice we're here, I guess.
Well,
I don't
so
know.
far, that's how they've been operating, and then blaming everything on Karen's attorney.
Right? The whole time. That's exactly what's been happening. These people are shit. Listen, I can't stress. Mary and Rachel, did you guys watch the trials at all? I can't remember if you guys had or not. I think Lainey, you watched it with us, or no, you didn't find us till Canero, didn't you? Who out here all watched either one of the trials, the first or the second one? Mary has not watched either of the Karen Reed trials. I cannot stress to you how shady every person in this case is. It's unbelievable. It's unbelievable. Rachel
is.
caught part of it. Okay. So
I feel like we have to revisit old testimony now.
we are. We're gonna have to. We're gonna have to. I think we'll save that for when we go over to the Ham v. Karen Reed and Turtle Boy. And I know we'll probably do that because guess what is in a lot of their exhibits? The transcript of their testimonies. So we
Oh,
might as well, yeah. Yeah, when you're going to that spreadsheet, you're gonna see, like, tons of, like, hundreds of pages, and it's all, like, transcripts from people's testimony during it, so and Colin's in that one too, so we'll save his. We'll revisit this old testimony for you guys, and
Well, I
that'll.
can't wait to get to the Turtle Boy suit now.
Yeah, it's wild. It is wild, but this one's the oldest, so we'll go this one's oldest and active, right now. I mean, the other ones are active too, but, um, so yeah, I think we'll save that'll make more sense because it's, the House defendants be Karen Reed and Turtle Boy, so I think I think that makes a lot of
Yes,
sense.
to
I'll factor that
properly
in.
understand the ridiculousness of the
Like,
people or what's going on, you have to see these people on.
you have to see
They're
them on the
shady.
stand. It
They're
is
shady. They're shady. So
unbelievable.
shady. If you haven't
Un
seen the trial,
Yeah, so I'll work that in then. This weekend, I'm doing all of my scheduling and all of my planning for like the next several months ish. So I will make a note. Actually, my Karen Reed one is open. I'm gonna go to my Ham one and write
can't
here at
wait to
the top,
revisit both Jen McCabe
add
testimonies.
add in House
But that'll take
defendant.
like 4 days to get through because she was on the stand for like 2 days in the first one, 2 or 3 days.
Yeah, testimonies. I mean, we can't watch the whole trial. Like they're each 6 weeks long. It's so many hours. I know because I stream
No,
the
but
second one.
there's
It's like
some very key
262 hours
players that do need to be rewatched.
in between.
For context,
To match documents. But yeah, they use the transcripts for a lot of the exhibits, so I guess we might as well, right? Between to match
I agree.
and violence. I meant to tell you that the other day over the weekend, but I forgot. Ah, Jen McCabe and the now improved Jen McCabe. It's a
Yeah.
wild. Yeah. So, all right, I will work that in for us then. All right. So, rather the very next day, and after Ms. Reed's counsel advised that he was out of state on May 28th, plaintiff's counsel sent an email on Friday afternoon of Memorial Day weekend, May 23rd, stating that he had communicated with Collins' counsel, that Collins' counsel had accepted a subpoena for Collins' deposition for May 28th, that he intended to proceed with a deposition on that date, and then attempted to serve an invalid notice of taking deposition among the parties. Oh, Diller. Should have known Diller was going to be, because remember, Diller only represents the O'Keefe family. There are different attorneys. Oh, I forgot to start off with attorney James Tuxbury appears as private counsel for Colin Albert. He
Oh, that's
represents
right.
all of the House defendants for everybody. So you'll learn more about him later, and you'll see him in the hearings, I bet.
Tewksbury. Is it Tewksbury? I don't know.
I say
Is
Tuxbury.
there?
I don't know what his name is.
I don't know either. But I feel like there's also like a city called Tewksbury. No, isn't that the name of the hospital that Lindsay Clancy's in? Tewksbury.
I don't know.
Anyway, I digress. Keep going.
This was obviously a coordinated effort between Collins' counsel and plaintiff counsel to interfere with Ms. Reed's subpoena and the Superior Court Rule 9C process. Diller would never, he would never try to be like, how can I make things shitty and weird? Per their plan, an hour after plaintiff's counsel's email, Collins' counsel then responded to Ms. Reed's counsel's May 21st email and took the position for the first time that Ms. Reed's subpoena was now ineffective. He did not explain why the change in the position or what occurred between May 21st and May 22nd that suddenly made it ineffective. Additionally, he refused to provide any dates in June, explain why Colin could not come back for a deposition after June 2nd, nor describe what reasonable search he had conducted or what documents he obtained related to the search. He did, however, reconfirm that Colin did not intend to produce any responsive documents. No. The argument here can be brief. As described above, Colin is a relevant witness in this case. Ms. Reeds properly served a subpoena upon him and properly noticed his deposition among the parties. Colin asserted an objection to that subpoena, and the parties then began negotiating the scope of the document's request. On May 21st, when pressed on deposition dates, the reasonable search they conducted and responsive documents Colin had in his possession, suddenly Colin's counsel's position changed and they unilaterally declared the subpoena ineffective. The subpoena is not ineffective, and the court should compel Colin to comply with it. Regarding his attendance at the deposition, the court should order his counsel to provide 5 dates in June and July, other than June 25th through July 3rd, for his deposition, from which Ms. Reed's counsel will choose one. But we're already, this is June 12th. Is he still out of town at this point, or? Okay. As for the scope of the requested documents, Ms. Reed's proposed narrowing is appropriate. Specifically, it seeks documents in Colin's possession relating to Ms. Reed, Mr. O'Keefe, the investigation, criminal trial, and civil actions. It also requests communications from a list of individuals all directly related to this matter. The one specific area about which Colin's counsel raised a concern during the Superior Court Rule 9C conference was communications with Colin's parents, who were coordinating Colin's actions in the aftermath of Mr. O'Keefe's death and serving as a conduit between Colin and the MSP investigators. But as a compromise, Ms. Reed proposed to narrow the period to just a 4-month period immediately after Mr. O'Keefe's death. That too is appropriate, and the court should order the production of all responsive documents within 5 days of this order. All you need is Buffy's reenactment short. Oh, yeah, that's true. You got to go. Whoop, whoop. It was really good for the Karen Reed. Her and her, who was in the car? Karen, Jen, and Carrie. It was good. It was very good. We were just little innocent babies, streamers then. Now here we are. On the other hand, Collins counsel's communication on May 22nd is quite revealing in its refusal to explain anything about the reasonable search that they claim they did and what responsive documents they have. Indeed, they intentionally obscure addressing the responsive documents they found, despite making arguments about overly broad or unduly burdensome. For example, if there exist 100 text messages responsive to the subpoena, that's not overly broad or unduly burdensome, right? If it's just 100, like what's the big deal? But they refuse to provide that critical information. Rather, when pressed, they suddenly called the subpoena ineffective and then peddled the May 28th date to plaintiff's counsel once they knew Ms. Reed's counsel, who has prepared for this deposition, would be out of state. I don't know if that would ever happen, ever. It's probably totally happened that way. Dylan
This
was
is
like,
so crazy to me
right?
because this is the O'Keefe's lawsuit.
Yes.
They brought this. Why are you not putting forth, like, I don't understand this game.
I don't either. I don't either. I think maybe because they want to, their claim is that Karen did this all, so therefore they have to play along with everyone else. But I don't understand why they're also playing along with their nonsense. Because quite frankly, I it's one thing for, let's say, MSP and Norfolk District Attorney's Office not wanting to release documents. There are some validity into some things not being turned over, right? That we've learned about as we've been covering this, not as much as they like to claim, but there are things there. But even they don't want to cooperate. Like nobody wants to cooperate with Reed and her team at all. But then in all of their other lawsuits, they're like doing all sorts of crazy shit. So it's very weird to me. why everybody's being so dodgy. And again, if you didn't say or do any, this is civil court first and foremost. And they're all like, oh, our stuff will be leaked and then we'll be harassed. But on what though? It's all so suspicious. But you're right. It's a conspiracy that doesn't make any sense. Okay.
If it was the conspiracy and you just don't want people to talk about it, then you should have just let this go after she was found not guilty.
Exactly.
Just stop.
Right. Yes, we have clickbait lawyering and criminal crimes. And what was the other lawyering we learned about the other day? That
Ambush lawyering.
ambush lawyering. There it was in the Murdaugh, right? Was it Murdaugh or was it
It was
David
Murdaugh.
Chris?
No, it was
Okay.
Murdaugh. Because it was Creighton Waters saying that to Poot for handing him that thing that he didn't file yet, that Poot decided to put it into evidence.
Right. And they say that the court should not continuance this type of conduct. All right, so that's what they have to say there. I'm going to take this off screen to read the emails because I didn't redact shit. So, and people on the internet are crazy. And I know they're lawyer emails, but still, I'm not going to make it easier for people. So, I guess as these are not in order. Let's see. The date on this one is Friday, May 22nd, 5:36. Are they in order? Mm. Oh, I think they might be in order, friends. Oh, that's the first ever. I appreciate you, Rosenberg. Unlike other people, make it harder to understand. Oh, that's the subpoena. What am I reading? Oh, page 39. Okay. All right. So, yes, this is in the right order. All right. So Rosenberg emails the lawyers regarding Colin Albert's subpoena responses. So this takes place on Wednesday, April 29th. These are the exhibits that are attached, but like I said, I didn't even look through to block anything. So, all right. So he says, Chris, thanks for the call yesterday. I've thought about your team's proposal on consolidation and the subpoena to Colin Albert and have discussed them with our group. We do not agree to consolidate discovery in your client's defamation case with the O'Keefe litigation. As we discussed, we are already well down the road in discovery in that case, with almost all documents produced, multiple rounds of interrogatories and answers exchanged between all parties, and over 20 depositions scheduled in the upcoming months. Also, Judge Gilday has been insistent that we do all we can to stick to the existing discovery deadline in August. And I don't believe he would be inclined to allow consolidation that would necessarily require a significant extension of that deadline. Because remember, this case has been going on since 22, 23? In between, it was filed in between, 24. Because her first trial was spring 24. This was filed after, and then her second trial was spring 2025. The defamation case, the Ham v. Reed Turtle Boy, that was just filed in June. So, and yes, it's that crazy after 2 months of it being around. So it'll be interesting. Extension of the deadline. Also, although I know you weren't yet involved in the case, your clients previously resisted our efforts to make these proceedings more efficient by bringing our claims against them in the O'Keefe case last year. Then, when we filed those claims in a separate Superior Court action, they removed it to federal court, preventing any chance of consolidation. We do not think now consolidating only your affirmative claims, which your clients opted to bring in yet another Superior Court proceeding rather than in the existing federal case, would be efficient or fair. So the lawsuit that's Karen Reed's sues everybody, that is now a federal case. And so Ham went and did their own, and then Karen has another one that's just her and the police. It's a whole. We'll get there. There's a lot. Attached is a proposed narrowing of the documents subpoenaed to Colin Albert, particularly the portion of the last request seeking communications with Colin Albert's parents, as you requested in your R9C call. Please let us know if you will agree to produce documents responsive to these narrower requests. We reserve the right to seek additional categories of documents in the future pursuant to the applicable rules, but are willing to accept the scope of documents at this point prior to the deposition. So the other side was like, hey, can't we just combine all of this stuff for both cases? Which perhaps you could, but the judge also doesn't want, the judge is the same, by the way, on Ham v. Turtle Boy and Karen Reed, and it's Gilday on both of them, I think. Yes. So they could, but also they're on two very different timelines. But we did read a ruling by Gilday regarding, was it proctors? There's something about how they were only allowed to use it in those two cases. He responded about it somewhere, but anyway, or maybe we haven't gotten there yet and that comes later. I don't know. I did a lot of stuff on these over the weekend, so
I was
I
about to say, I
could
don't
be
think we
getting
got
confused.
really. Did we
Okay.
get to Proctor? I don't think we've gotten to Proctor yet.
No, we talked about Proctor, right? They were trying to like his deposition and they were all like,
But
somebody
did we get
told
to his
everybody.
ruling yet? I don't remember. It's been a while. See what happens when we're gone for a week?
Yeah, I
Right,
know,
or
right?
no.
I know. Yeah, we did. We listened to the emergency hearing for the protective order for Proctor, where he agreed to impound Proctor's affidavits for up to 30 days, but denied his protective order request and ordered him to do his deposition. So
Oh yeah,
that was the
that part.
ruling there. But I think it comes up again later in July. So
Yeah, because
yeah.
there was some issues with that deposition.
Right. So they send them that. The next email is from Charles Waters, which is one of Reed's attorneys.
Waters
Mm-hmm.
related to Creighton.
Great. Maybe. I don't know. To the to Colin and the Alberts lawyers. All right. So Kirian. One, you must have missed my earlier response to Chris's email. I've placed it below chronologically for clarity in our communications. Thank you, Mr. Waters. I appreciate that.
What?
Your statement below, your statement below that no further documents exist that you are willing to produce at this time is, of course, the exact issue with which we are concerned. 3, please describe the reasonable search you claim to have conducted. 4, please produce all responsive documents that you are willing to produce at this time, pursuant to the reasonable search, regardless of whether you think Ms. Reed may or may not have them already. 5, relating to the response documents that you are not willing to produce, please identify what they are, including, are there any responsive documents relating to the investigation, criminal trials, and civil actions? How many? B, regarding Colin Albert's parents, what is the volume of responsive documents? As you know, we've reduced the scope to communications in a 4-month period. And other than his parents, did you reasonably search, identify any responsive communications with Paul O'Keefe, Courtney, Elberg, Carrie Roberts, Brian Higgins, Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, Allie McCabe, Brian Albert Jr.? There's lots of Brian's. Were there any responsive documents that you are not willing to produce relating to all communications with Chris? And they do all the people. All right. We'll skip that paragraph. As for Colin Albert's deposition, we served him with a subpoena on April 21st for a deposition scheduled on 4/29. We began communicating with your office on 4/23. Last night's email 5:20 was the first time you told us that Colin Albert is away from Massachusetts area for a significant period due to work-related matters, beginning on June 2nd, 2026. You then provided 2 dates next week for his deposition, both of which do not work for me because I am out of the state both days. Please provide additional dates in June as I requested yesterday. If necessary for Mr. Albert's schedule, I would consider taking his deposition on a Saturday. The judge will like that because he's like, you all should be working on the weekends and federal holidays, which is bullshit,
Right?
frankly. Remember, he's like, why aren't you guys working on June 9th? Or
I mean, you've
June
had like 2 years off. Get to work.
right? If you claim to have no dates in June, please explain the details of why Mr. Albert can't come to Massachusetts at any time in the month of June for his deposition. And when you first learn this, I look forward to your response. Chaz. Oh, he goes by Chaz. Ooh.
Eh,
I don't know why, but
Chaz is usually short for Charles.
yeah, it is. Yeah.
Ugh. I don't like it. I don't
know either. Okay.
I automatically think somebody's pretentious.
Yeah. All right. So next we have an email from Mark Diller. Remember, he is the attorney for the plaintiffs. Sneaky little
He's
weasel
my
Diller,
favorite.
who sends this out to all of the attorneys for everybody.
I feel like we need a good op. He's perfect foil for Rosenberg. I love it.
That's true. That's true. We have a fun time making fun of him. All right. So he sends this to them Friday, May 22nd at 4 o'clock. Counsel, please note the following. 1, Tuesday's deposition of Mikowski is off, while the O'Keefe and Karen and Reed teams confer on Reed's objections to the matter. Who's Mikowski? I don't know who that is.
Is it Mikowski? It's not. I can't see it. I need to look at it. The word. How's it spelled?
Mackowski. Is it her sister-in-law? No. 2, we were notified that Ms. Collins and Ms. Bombardier need to reschedule the Thursday depositions. Who's Ms. Bombardier? That's a fun last name. 3, given that all parties were already blocked for the day and our need to move depositions forward, we investigated and discovered that Colin Albert's deposition was canceled by the Reed team previously and never renoticed subpoenaed date. Okay. Albert's counsel has agreed to accept the subpoena and to appear next Thursday at his counsel's office for deposition. 4, Friday's deposition remains on the calendar and has been confirmed that it is going forward. Have a nice holiday weekend. I look forward to seeing you all next week. I'm sure he does. All right, so then there's that. And then they have another email that is from the Alberts, Colin, their lawyer to Karen Reed's team.
The Mikowski that I can find is Mikowski's name of the private investigator who worked with Karen Reed's defense team.
Oh, okay. He's the one that went inside and like took pictures of the house and stuff, right?
Yeah.
Yeah. Okay. I think he was
So
at the trial.
Paul Mikowski.
Did he testify for the defense in the second one?
I think so.
I think he did. And it wasn't very long.
No.
But
Paul Mikowski, that's the name of the investigator.
Okay. He either testified or they did like a voir dire of him or something, I feel like. I don't remember. All right. So about an hour and a half after Diller's email, Colin's email sends this to everybody. Chaz. Respectfully, I decline to engage line by line dissection of our responses and objections to the subpoena. Oh, are you Meredith Brooks from the Real Housewives of Salt Lake City? I'm disengaging. My housewife friends will know what that means. This subpoena was issued to a non-party pursuant to Rule 45, and you are well aware non-parties are afforded specific protections from undue burden under the Massachusetts Rules of Civil Procedure. We have made our position clear that this subpoena exceeds permissible bounds and violates these protections. Moreover, we have now inquired twice without receiving any response regarding the relevance of Colin Albert's testimony to the wrongful death action. Don't act like you don't know. The deposition of that case requires answering a singular question: whether your client is responsible for the death of John O'Keefe. Colin Albert was not present at 34 Fairview at the time of Mr. Keefe's death, allegedly, and you have produced no explanation as to how his testimony assists in resolving that central issue. Absent such an explanation, our objections to the subpoena remain unchanged. Notwithstanding the foregoing objections, we have attempted in good faith to reach a reasonable compromise by agreeing to produce the following categories of documents. Oh, okay. 1. Communications from January 28th to present between Colin Albert and Michael Proctor, Yuri Buchanan, or any other law enforcement official associated with the investigation and criminal trials of Karen Reed. And 2. All communications between Colin Albert and any other individual or at or around January 28th pertaining to the circumstances surrounding the death of Officer O'Keefe and the investigation conducted into the same. So, okay. Why don't you want to see the other stuff? But okay. I have confirmed that only a single text exchange is responsive to those categories. Communications between Colin Albert and Allie McCabe regarding the time Ms. McCabe picked up Colin Albert at 34 Fairview. That text exchange was used by Ms. Reed's criminal defense counsel during Colin Albert's cross-examination at her first trial, which supports our position that it is already within Ms. Reed's possession, custody, and control. However, as I previously stated, if for whatever reason Ms. Reed no longer has access to that exchange, we are prepared to produce it upon the issuance of a new subpoena, as the prior subpoena has expired and was not renewed. Oh, geez. Well, I'm sorry. This is expired. So do it again and waste more money, and then we might cooperate.
I was about to say that's exactly what it is. Just no, we're gonna make you spend the money.
Regarding Colin Albert's deposition, we've received a subpoena today from the plaintiffs in the wrongful death suit for his deposition on May 28th. Finally, I am not in a position to provide further detail regarding my client's availability constraints beyond what he has already been communicated. Colin Albert will be unavailable for an extended period after June 2nd, 2026, due to work-related obligations. Accordingly, we look forward to completing his deposition before that date. I mean, you're not in a position to provide. Okay. See, this is kind of like the things where it's like, why are you being so fucking weird? Why are you being so weird and shady about things? I don't understand. I don't understand. If he wasn't there, then why aren't you like, yeah, homie, that's all we got? Not file a subpoena again. Also, when you said it was an undue burden, it doesn't sound like it was to me. So, okay. Next we have, oh, I already have that one up. So that finishes that document. All right. And so now we can share this one. This is much longer. I don't know if we'll be able to get through all this today, but we will see. We will see what we get through. So this is, I don't have it on the screen. My bad. I forgot. This one. There we go. There we go. Now you can see it. This is Colin Albert's memorandum of law in opposition to defendant Karen Reed's motion to compel. So this document here has 21 pages that we're going to read. Colin's affidavit, text message, a police report from October 17th, 2023, emails, social media posts. There's a lot going on in this document that they submitted. So we will get into it. We'll definitely are not going to finish it today, but we'll pick it up tomorrow for sure if we don't. So let's see real quick. What are y'all saying over here so I can take a little drink break? Chuck is the better shortened version of Charles. That was your dad's name. Oh, his birthday was. Oh, you missed it. I'm so sorry. But, oh, and your dad was birthday was yesterday too? Oh, that's interesting. Yes, that's right. He's not available after 6/2, but only one day beforehand. Yes, yes. But his lawyer can't tell you why, which is weird, but okay. You think
I think that's weird too. Like, why? Shouldn't you know what's going on with your client?
you should, Mary. Definitely. Mary says, I think I'm going to start using undue burden at work when they ask me to do things.
Oh,
As you
absolutely.
should. Be like, excuse me, this is an undue burden. And
I feel like when somebody asks me to make a impromptu thumbnail, I'm just gonna be like, this is an undue burden.
take it up with my lawyer. You're going to have to refile your request. It's
Gonna need to refile
expired.
that your request expired after Sunday. Anything you want after Sunday has to be a renewed request. File it accordingly.
Hey, thanks. Might as well. What's crazy to me is like how much of these shenanigans are allowed to go on. Because I feel like if we were to do this, we would somehow end up in jail. Like, I just don't understand. But okay. I know it's a civil case, so it's not so much like that's going to
I
happen, but
know.
still,
I
even in
I
the
feel like
criminal cases, it was like, what?
I feel like I'm learning that the civil world is just who runs out of money first
It absolutely is. That's what we have learned. Yes.
or
This
who's
year.
willing to go into debt.
Mm-hmm. And that anything goes. Shenanigans can be afoot. You don't need to put the truth in everything. Nobody's really held accountable. I already didn't like civil courts. Excuse me. Not a fan, but now we're in it and we're in it deep. So here we are.
Yeah, in a few places actually, right?
Yeah. And a whole lot of stuff. Criminal court just makes so much more sense.
It really
Um,
does. Even when
because
it doesn't, it makes
even when it
sense
doesn't.
why.
Mm-hmm. Yeah. Civil court, just bananery over there. It's crazy. All right. So non-party Colin Albert, by his undersigned counsel, respectfully submits this motion or memorandum in opposition to Karen's. Reed's motion is a piece for her cynical, years-long campaign to scapegoat Colin and many others in order to deflect from her own culpability for Officer John O'Keefe's death. Oh, we are coming out with fire right away. Yikes. Okay.
Wow.
Reed's motion is littered with material misrepresentations, thoroughly debunked claims, cheap character attacks, and outright knowing falsehoods that have no place in court filings.
It's swinging.
Wow. Okay.
Like we're not
Yeah.
pulling punches here. We're gonna put it right at the top. You got my
Yeah.
attention. Keep
Right.
going.
I guess we're going to be reading this all today. That's fine. On the dispositive issue before this court, whether Reed is responsible for the death of Officer O'Keefe, Colin has virtually zero relevance. It is undisputed that Colin was not present at 34 Fairview Road when Reed and Officer O'Keefe arrived in Reed's car in front of the home. In any event, whatever marginally relevant evidence Colin may possess does not justify the extraordinary burden imposed on him, a non party, by the subpoena. What extraordinary burden? What even qualifies?
Undue burden.
Like, so dramatic. You decided you don't have civil court money or fast lane ticket money. Yes, that is how I determine my level of poor, too. Yes. The subpoena is breathtaking in scope. Oh my gosh, what a
Wow.
flair for the dramatics.
What is clickbait lawyering?
Wow.
Sir, you were the one pointing the finger at him.
Right? The subpoena is breathtaking in scope. It seeks documents and communications entirely unrelated to the death of Officer O'Keefe. It demands, among other things, all communications with no fewer than 12 individuals, including Colin's own mother and father, spanning over 4 years without any relevance to the death of Officer O'Keefe. How do you know that? Have you seen them?
I don't think you can declare parental privilege.
No,
I
there's
think
no
it's like
such thing.
spousal privilege, but like
Because he was not
not
underage. I think underage you can,
parental privilege.
but I don't
I
know
don't
that
even know if you can
100%.
do
But
that either.
I don't know 100% if that, I would say that's the one scenario where there might be an argument for it,
I don't know
but I
because
don't
parents
know.
get in trouble for their kids all the time.
Exactly, exactly. So I don't know how that works. I've never seen it to know one way or the other. So and say geez, I don't think is here today. So let's see, where was I? She's probably busy watching the trial. It's probably why I haven't heard from her in like a week. She's like, yeah, I'm in deep. No, I don't know what she's doing. Where was I? Okay, so these requests are not tailored to any discrete issue in this wrongful death action, or indeed any discrete issue at all, and are not curated to avoid undue burden upon a third party. Colin agreed to and did review his records for all communications with police officers pertaining to the investigation into the death of Officer O'Keefe and Reed's criminal trials and all communications around January 29th, 2022 regarding the investigation into and death of Officer O'Keefe. Colin has no responsive communications except a text exchange with Allie McCabe, confirming that the two arranged for Allie to pick Colin up from 34 Fairview at 12:10 a.m. on January 29th, 2022, a text Reed has had since 2023. Reed's demand for a deposition is equally flawed. On April 21st, 2026, Reed served Colin with a deposition subpoena for April 29th, commanding his appearance just 8 days later. Horror. The horror. The shock and horror.
The shock and horror.
There we go. We're going to
Shock
need
and
that.
horror.
We're going to need those accents for role playing in the Hamlet. I'm going to work on it. I'm going to work on my
I got to go back to
Boston.
Boston for a little bit.
Right. Despite the short notice to a third party witness, Colin was ready and able to appear for the deposition. However, Reed canceled Colin's deposition less than 48 hours prior and never issued a new subpoena. Reed is moving to compel against a non existing subpoena. Further, on May 19th, 2026, Colin's counsel learned that Colin had applied to enlist in the United States Army. And on May 28th, Colin's application was approved. How old is he? How old is Colin Albert? Let's Google this because I am very confused about how old he is during all of this. That's kind of late to join the Army randomly, don't you think? I don't know. Colin Albert age. He is 22 years old. He
So
was
how old?
17. He was 17 years old at the time of John O'Keefe's death
Okay.
and 20 years old during his testimony in May 2024.
Okay.
So he said that he was out getting drunk and he was definitely super underage. Okay. All right. So I guess 22 is not that old to enter the Army randomly,
Mm.
right? I assume. Weird
Well,
this kid is, I'll be honest. When you see this kid, you're gonna be like, this guy? Really? Okay, that's weird. I don't picture him in there, but okay.
it's just weird how last minute it was.
Yeah.
It's not. I've never. I mean, okay.
Because did you go in
I
right
got.
after high school or
I did.
okay.
Well, I was in the Army twice, but
Oh, okay.
yeah, twice. Twice I enlisted, but
Hmm.
yeah, I was dumb enough. I went back again. One much later in life, and one right out of high school. Yeah.
Oh, Mary brings up a good point. That's the age of getting kicked off my parents' insurance and don't know what to do with my life.
It's 26 when you get kicked off parents' insurance.
Oh, is it? I don't know.
Mhm.
All right. So he decides he's joining the Army. He is now 22 years old. And on May 20th, Colin's application was approved. As a result of his enlistment, Colin was ordered to report to basic training outside of Massachusetts on June 2nd. On the same day, May 20th, Colin's counsel informed Reed's counsel that if they intended to reschedule Colin's deposition after canceling it, Colin would have limited availability and offered the only dates on which Colin was available before this extended absence beyond the close of fact discovery. Reed's counsel declined those dates, despite having 10 attorneys capable. Sorry, oh, the shade. Reed's counsel declined those dates, despite having 10 attorneys capable of taking his deposition, and the fact that Reed was supposedly ready to take his deposition on April 29th before she canceled it. Instead, Reed, without indicating whether any of her 9 counsel were available to take Colin's deposition prior to June 2nd, demanded that Colin, a third party in this lawsuit, sit for a deposition on dates he said he would be unavailable. Then on May 22nd, 2026, Colin received a deposition subpoena from the plaintiff's counsel after the plaintiff's counsel learned of Colin's limited availability. Convenient. Scheduling his deposition for May 29th, 2026, all counsel to this action except Reed attended Colin's deposition that day. So none of her lawyers went that day. Oh, that's interesting.
But was it because they couldn't?
I don't know. I mean, we knew Waters couldn't because he said he couldn't make it. But also, like, yes, they do have like 10 attorneys, but I feel like her team is doing what her defense team did. And this generally happens a lot with teams of lawyers is they divvy up the witnesses, the information. So that way, one lawyer only has to be knowledgeable in this one area. And
Yeah,
that's
that
what her
makes
criminal
sense.
defense team did. So I think the reason, yes, she has 9 or 10 lawyers, but Waters must be the one focusing on this. So it to have one of the other lawyers come in doesn't mean that they know actually a lot about it. That's my guess of what's going on because that's a lot of people to prepare depositions for. It's a lot going into that. So it's not like, no, you can't really bring in one of the other lawyers who have very little to know about this witness specifically.
Right. That
So,
makes sense.
yeah. So compounding these issues, on June 3rd, 2026, Reed's counsel falsely told this court, without Colin's counsel present, that Colin had refused to appear for the deposition. This was unequivocally false statement that appears to have been designed to prejudice third-party Colin before this motion was even filed. This misrepresentation to the court in violation of Massachusetts Code and Reed's refusal to genuinely remedy this misrepresentation further warrants denial of this motion as a sanction.
Oh, wow.
Rather than accommodate, right? Rather than accommodate a third party witness's schedule, Reed filed this motion, a classic hallmark of discovery designed to burden and harass rather than to obtain information.
Wow.
The victimhood in this, oh my goodness. Indeed, the only gamemanship at play is that of Reed and her counsel, who have misrepresented to this court the circumstances of their attempts to seek discovery from Colin. Everybody's using Reed as the scapegoat in this. But I have yet to see that in this case. So, all right. So the factual background, their version of a factual background on the events of January 29th, 2022. On the evening of January 28th, 2022, Colin was a 17-year-old senior at Canton High School. That evening, he was at his aunt and uncle's house at 34 Fairview celebrating his cousin Brian Albert Jr.'s birthday. I believe his 21st birthday, who also was on leave from the military, along with a few of his cousin's friends. At 11:55 p.m., Colin texted his close friend, Allie McCabe, to coordinate a ride home because he had a midnight curfew. Allie texted back that she had to drive some other people home first. At 12:10 a.m., Allie texted Colin to say that she was here, and Colin responded, okay, and then Colin left 34 Fairview at that time. On his way outside, Colin saw his aunt, Nicole Albert. However, Colin never saw Reed or Officer O'Keefe. Instead, the disputed evidence reflects that Reed had not left the Waterfall Bar and Grill until after Colin left 34 Fairview. Allie drove Colin home, where Colin remained for the rest of the evening. The defamation campaign against Colin. Oh my goodness. Right. Surely, you know what? Maybe if they didn't all like replace all of their phones right afterwards, that's kind of weird, huh? Conveniently. Hmm. Yes. Surely, surely they can download them from the court or the cloud, right? The initial aftermath of Officer O'Keefe's death largely did not impact Colin. Colin was not present and was not a witness. He was also barely knew Officer O'Keefe, who lived in Colin's former neighborhood. Following the initial shock, Colin's high school life returned to normal as he prepared for post high school plans at Bridgewater State University and then started freshman year there. That all changed on April 12th, 2023, when Reed and her counsel publicly and falsely accused Colin of being responsible for Officer O'Keefe's death. Reed had no actual evidence to support that claim. Instead, months later, her counsel, attorney David Yannetti, would claim an individual called with a tip and identified Colin and his uncle as the responsible parties. That individual was eventually identified as Steve Scallon, a Canton resident who previously admitted that he had no personal knowledge of the events of January 29th, 2022, and that prior to meeting with Yannetti, he had never even heard of Colin Albert. Oh, that Scallion name makes more sense because I think I've seen it elsewhere in the Ham one. So, okay. There was an investigative memo from Yuri Buchanek to Detective Brian Tolley regarding the interview with Scallion. Okay. Okay.
Scanlan. Scallions are
Scanlan?
onions.
Oh, yeah, Scanlan. Scallions are onions. I said a lot of words today, and then words get hard. Whatever, we'll still call them an onion. A rap Scanlan. Uh, all right. Further, days after Reed's April 12th court filing and in coordination with Reed, blogger Aidan Kearney, aka Turtle Boy, published his blog in which he accused, without any supporting evidence, Colin of killing Officer O'Keefe. The centerpiece of Reed and Kearney's false accusations against Colin was a Facebook photo taken a month after Officer O'Keefe's death, showing Colin had scraped knuckles on his right hand. Reed's reliance on his photograph in the motion to imply that Colin killed Officer O'Keefe is a misrepresentation. Indeed, prior to her first criminal trial, Reed has possessed photographs of Colin taken after Officer O'Keefe's death and prior to the Facebook photo that clearly shows no scrapes on Colin's knuckles or injuries to his knuckles. For the court's convenience, samples of such photos with timestamps are displayed below. You were asking me when I get hungry during our break today. It's now. I told you it was like between 3 or 4 is when I finally I'm like, okay, I'm hungry. I should probably get to eating things. All right, so here are some photos. Let's make this bigger here so we can see these. These are, oh, that's not how that works. Let's see, this first one was February 11th, 2022. Didn't he just say it was a month after? That's not a month, sir. It's literally a few weeks. I don't really see his hands. I don't know what we're supposed to be looking at. What did he say these were? Hold on, sorry.
Knuckles.
Samples with times. Oh, showing no scrapes. Okay, sorry. All right, so these are from the 11th. Okay, that doesn't really say a lot, but okay. 2 weeks later, can your hands heal? They have a whole debate about this, don't they?
I have no idea. I don't remember any debate about it. But like I said,
Oops.
I delete files after I don't need them anymore. So I don't just have a permanent storage. I don't have a data center in my brain.
That's true. Jazz hands. That's right. Pull up, bitch. You remember Bang Bang or whatever. He's
Oh,
a douche kid. All right. In other words, as Reed well knows, the evidence she has submitted to this court lamely suggests that Colin may have sustained injuries to his knuckles in connection with the death of Officer O'Keefe could not possibly support her theory because earlier photographs show the absence of an injury. But do we also know that those didn't have any filters put over them? Is that the exact metadata of those that we were
no,
just
we
showing
have
here?
PDF control, paste, copy
Mhm.
paste, just like the text messages.
Yeah. See, that doesn't work. That doesn't work in the court of law at all. The impact of Reed's continued attacks on Colin's character and reputation has been catastrophic. While such is the question, or I'm sorry, while such is the subject of the pending defamation action brought by Colin against Reed and others, it is noteworthy for purposes of this court's consideration of the motion. Since Reed conjured up the baseless allegations that Colin was somehow involved in the death of Officer O'Keefe, Colin has had to drop out of college and has been continually harassed and defamed online. I'm pretty sure this is not the reason that kid had to drop out of college. All right. if you saw his testimony, the fact that you'd be like, I dropped out of college wouldn't be a surprise to me. I'm not calling him stupid, and I don't think there's anything wrong with dropping out of college per se. It's not for everybody at all. Even people like it just depends what you're into. But him of all people, you'd be like, yeah, that checks out. That probably makes a lot of sense there. But I doubt it was because of everything going on. So we'll see. Dozens of individuals have confronted Colin, both at home and at work, accusing him of being involved in a murder, which has caused him to fear for his overall safety on a daily basis. Nevertheless, Reed continues, even in the present motion, to push a baseless fantasy that Colin was somehow involved in the death of Officer O'Keefe, even though
A
Reed and her counsel,
fantasy.
yes, no, their claims against Colin are patently false. Okay.
A fantasy is something you want. Like I don't know that fantasy was the right word for that. Even if it was delusion or like what I don't
Right.
know I would ever call it a fantasy as a descriptor.
Right. Laney's like, this is bullshit because Colin was asked about his scab knuckles on the stand and lied that he slipped in the snow and fell on his knuckles. That is
Yes.
absolutely what was said there. But they're like, maybe the judge doesn't know that, so we're just not going to do that. Like I said, we will definitely be rewatching people's
Yeah. I don't think we
testimonies.
have a choice after
Mm-mm.
like especially after like these documents having to go back and refresh what did Colin say?
Yeah. Maybe we'll go ahead and watch his. this week as well. It's like 2 hours, but that's fine. I'll watch it again because I don't remember a lot of it, but I do remember that when I watched it, I was like, bro, you are clearly lying on the stand. Like, what are you doing? Um, so yeah. All right, where was I? False. Reads April 21st subpoena. The motion asserts that on February 11th, 2026, Ms. Reed's attorney properly served a notice of taking deposition of Colin for April 29th. The assertion is misleading. Reed fails to disclose that such notice was never sent to Colin or his counsel. Instead, on April 21st, 2026, more than 2 months after Reed's attorney issued a notice of deposition to counsel of record, Reed's counsel personally served Colin with the subpoena at his home, commanding him to produce a trove of documents within 6 days and to attend a deposition within 8 days. On April 27th, 2026, undersigned counsel served responses and objections to the document requests obtained in the subpoena based on inter alia. I don't know. My son's getting ready to take Latin, so I'll know how to say these words properly. Because I
Inter
guess I'll be
alia.
learning inter alia. Okay, so we're also going to be learning Latin together, friends. You guys too. Why not? We'll do it together. The requests overbreadth, vagueness, and ambiguity. At no point, hold on, is one of my dogs outside? I don't think so, but one might be. It might be the one that never lets me know that she's outside. No, there, she's not outside. Oh, I bet it's the squirrels. Squirrels eating their acorns. They eat them in the tree above my house, and then they just fall down. Like you have to kind of run from my door to like get out of it because they just drop all the pieces on you constantly because the squirrels are assholes. So I
Nice.
have a whole bunch of
Inter alia means among other things.
Oh, okay. Okay.
We can't just write that. We have to be all
Play.
fancy.
Do you believe Colin would be able to prove damages against Turtle Boy? I think he would. Dropping out of college is a life altering decision, but there's a lot. Would be, I would think, other things that he would have to prove that it was solely because of this. One, he would need interact. There are tons of people who drop out of college for numerous reasons all of the time. People can say whatever about why they dropped out, but he would need some proof of like, yeah, this is what was happening every day, and that it directly was because of Reed and Turtle Boy. Now, listen, I know Turtle Boy has his own show. He's on several times, and but other people are going to do what they're going to do. I have not gotten in. We have not gotten into the Hamvee Reed Turtle Boy defamation, so I don't know if there's more in there. So I'm going to kind of like reserve that, but just right off what they're saying now, I mean, he can say that's why. What were his grades at the time? What all, was going on? Because it can be a lot. And as I said, college isn't for everybody, which is okay. You know, I dropped out my second year of school. Um, it happens, but we'll see. I don't know if it says it in here or not. We're all reading it together. So let's find out. But I hope you're doing well today. Um, your stepsister teaches Latin. Nice. Oh, you're there. There's my pretty dog. I know. Hi. You're like, were you looking for me? Yeah, they're such assholes. All right. Don't you have to be leaving, Buff? Or you still got like another 15 minutes, right?
I got about 15 minutes till I have to say
Okay.
goodbye.
That's true. Nobody forced him to drop out. That's a fair point. Also, were online classes available? I mean, we'll see when we get into the defamation lawsuit there that they have. I will be interested to see what they've submitted. I'm sure it's talked about. But again, you can't just go, you got to have proof about things. And these people, I'm happy to be back too. I had no power last week for a couple of days. So that's why there was no Karen Reed stuff. But yes, we're here. All right. Where was I? In response to Colin's responses and objections on April 27, 2026, counsel for Reed requested dates and times to meet and confer pursuant to Massachusetts Code. In the same email, counsel for Reed wrote, under the circumstances, it makes sense to take Colin Albert's deposition after all responsive documents are provided. Undersigned counsel promptly responded, seeking clarification regarding Colin's deposition. To clarify, are you canceling the deposition scheduled for April 29th? Reed's counsel then responded in relevant part, confirmed that Wednesday's deposition will be rescheduled to a different date. It doesn't sound like canceled. Those are two very different wordings there. You guys are asking if it's canceled, and they're like, no, we're just going to reschedule. I think cancel to me just means we don't have another one. But okay. On April 28th, 2026, undersigned counsel conferred with counsel for Reed regarding, inter alia, the scope of the document request. At the conference, undersigned counsel first inquired as to why the subpoena was served on Colin, a non-party, with such little compliance time. Counsel for Reed did not provide an explanation, instead simply cited Massachusetts Code, which permits a subpoena to be served with a 7-day compliance time. Undersigned counsel next relayed the position that the subpoena sought irrelevant information and was overbroad, unduly burdensome, and harassing. By way of example, undersigned counsel highlighted that on its face, the subpoena request over 4 years of communication between Colin and his parents without making any attempt to narrow those communications by topic. In attempting to reach a compromise on the subpoena's scope, undersigned counsel inquired as to the relevance that Colin has to the wrongful death action. Given that he was not at 34 Fairview at the time, Reed and Officer O'Keefe arrived outside. Counsel for Reed stated that they were not required to provide any good faith basis for sending the subpoena to Colin, and simply alleged that Colin is associated with plaintiff's IIED claim and false narrative allegations. Undersigned counsel relayed that the subpoena was too broad, that it was impossible to make a counter proposal to Reed without any guidance regarding Colin's relevance. It was impossible, guys. Impossible. The next day, counsel for Reed transmitted what they alleged to be a counter proposal to the original subpoena following the April 28th conference. Notice they haven't told him at all yet that he was like going to the Army.
Mm-mm.
No. The next day, oh, I already read that. I'm sorry. However, this counter proposal was nothing more than a mirror image of the original subpoena, except for the fact that Reed slightly narrowed the scope of communications between Colin and his parents, apparently in response to the illustrative example of overbreadth that undersigned counsel gave during the April 28th conference. Hi, Kelly. What happened? Oh, we're just reading the Colin Albert stuff from the wrongful death suit from June. So Colin Albert is not cooperating for subpoenas and documents. The whole thing, to no one's surprise. On May 5th, 2026, counsel for Reed served 6 additional subpoenas on non-parties: Allie McCabe, Jennifer McCabe, Matthew McCabe, Brian Albert, Nicole Albert, and Brian Higgins. Notwithstanding the concerns raised in Colin's responses and objections during the April 29th 9C conference, these additional non-party subpoenas were identical to the objected to subpoena originally served on Colin. At this point, it became apparent that Reed was not seeking meaningful discovery in an effort to locate relevant information related to the wrongful death case, but was using her subpoena power to obtain over 4 years of unrelated communication in an ongoing effort to harass and retaliate against individuals who had the audacity to give information to the police and testify at trial. The audacity, guys. How
Oh
dare
my
you?
God.
The dramatics.
Right?
Thus, since
They
Karen, go ahead. Yeah.
Oh, it just says this side's so theatrical.
Yes. And these are the same Colin's attorneys are the same ones for Ham in the defamation suit.
Oh,
So
so okay, so they're
I,
just going to be a
yes,
shady.
it's going to be, I bet those filings are so good. If this is what we got for this one, this is what?
Is Rosenberg? Wait, it's Ham versus Turboy and Karen Reed,
Yes.
right?
Yes.
Rosenberg is also her attorney on that as well.
Yes, they're the same
That man
lawyers.
ain't got no time.
No, he doesn't. I believe
Oh my God.
there's the same lawyers on all of them, but I don't know if that's entirely true. On the federal one, I don't see why it wouldn't be, but I believe it's for anyone. They're just the same lawyers because why would you file different ones? But
Oh my Lord.
yeah.
This man
So
does not have time to sleep.
well, now maybe like with the Ham one, like maybe one of the other attorneys is more like maybe this is the one that Rosenberg heads up. Maybe one heads up. I just don't know because I haven't read the documents to see, but I do know that they're in there. So
Wow. I'm going to take this pause to tell everybody bye. I have to leave to go pick up my baby Buffy. And instead of interrupt you during your reading, I'm just going to bow out during this little break.
that's fine.
I'm going to be listening because I want to hear the rest of this.
Be listening and in the chat for the drama.
Well, I'll
All
be
right.
driving, but I will be listening.
Oh yeah. Please
We don't
don't be in the
text and
chat and drive. Yeah, don't do that. Normally I'm like on the phone with you when you're in the car. So
Yes.
all right. All right. Bye, babes. Be safe.
Bye.
We will see you later. All right. Let's see, where were we? Okay. So at this point, it became. Oh no, wait, I was already there. Thus, since Reed's team refused to do so, it became incumbent on counsel for the Alberts, the McCaves, and Mr. Higgins to propose reasonable topics of communications that they believed to be within the scope of the issue presented in this case. Following receipt of the May 5th subpoenas, counsel for the Alberts, the McCaves, and Mr. Higgins confirmed internally to do so. Let me just real quick make sure that these are the same. Who's the lawyer that I said was on this? This was Huxbury, right? Let's see. Mark Gatias, that's for them. Parents, McCaffrey. Is okay, so Damon is all right. Karen Reed's team is on the same. Oh yes, okay. So Murphy and Tuxberg are the attorneys who's writing this for Jennifer McCabe, Brian Albert, Colin Albert, Brian Higgins, and the McCabe's. So they all have the same lawyer, I guess. So and Christopher Mattai, whatever. So okay, yes, all the same people. All right. Where did I go? All right. Following receipt of the May 5th subpoenas, counsel for the Alberts, the McCabe's, and Mr. Higgins conferred internally to do so. D. Colin Albert joins the United States Army. On May 19th, 2026, Colin informed counsel that he would likely be joining the U.S. Army and that if so, he would be forced to leave the Massachusetts area for initial and basic training beginning on June 2nd, 2026, and that he would be gone until the fall of 2026, which is past the date of discovery that they're supposed to do in this case, coincidentally. But okay. On May 20th, 2026, Colin confirmed that such would be the case and that his situation would limit his access to phone or email communication. The same day, counsel for Colin notified counsel for Reed of for Reed of Colin's sudden scheduling conflicts, proposing 2 dates for Colin's deposition, the 28th, May 28th and May 29th, that were within the same compliance period of the notice given to Colin by Reed's original April 21st subpoena. Colin originally requested that the circumstances of his unavailability remain private, given the profound levels of harassment and intimidation that he has previously been subjected to from Reed, non party Aidan Kearney, and their following, including dozens of instances of third parties showing up to his home, workplace, and school. To protect his best interests and safety, Collins' counsel provided unqualified representations of his unavailability without mentioning it was to join the Army, instead, stating that it was work related and that this was something Collins' counsel had just learned as well. You can't join the military when you have legal issues? Is that so? I think I might have got a text message. Let me see. No, I didn't. Okay, we're good. I this is what I think as well. That's what I think as well, because this is also so he is leaving the McCabe's, and then when did they file their lawsuit? Um, It was the defamation was filed April 16th of this year. So they, got the subpoena notices for deposition right after they filed their stuff. So it's all happening at the same time. But we didn't really want to cover each case and when it gets very confusing very fast. So we broke them up. But at this point in time, they filed this case on April 16th. So in the same May 2026 email, counsel for Colin relayed a proposed scope of potentially relevant relevant communications to the wrongful death action, which included communications from January 28th to present between Colin and A, Michael Proctor, B, Yuri Buchanek, and C, any other law enforcement official associated with the investigation and criminal trials of Reed, and 2, all communications between Colin and any other individual at or around January 28th, 2022, pertaining to the circumstances surrounding the death of Officer O'Keefe and the investigation conducted into the same. Counsel also relayed in good faith that Colin had undertaken reasonable efforts in the prior weeks to locate communication responsive to those categories, but with the exception of a singular text exchange, no other responsive communications existed. None? None at all? I find that hard to believe when your whole family is like wrapped up in, being accused of all these things and you've never once talked, whatever. We're supposed to believe a 17 to 20-year-old isn't talking about it somewhere on the internet in some capacity, whether in text messages, whether in Snapchat or whatever the cool kids are doing now these days. Like, come on, that doesn't even make any sense. DM to what? Oh, are you talking about Kelly's Etsy? Yeah, you can drop that in there in the Discord. Kel, that's fine. So you can't join if you have pending charges or are on probation or pending court dates. Legal issue is overly broad statement, but this is civil. Does civil factor in? I imagine criminal, and for obviously very good reasons. But I'd be interested to know. Thank you for doing the research, Rachel, for us. You are quite the little info queen today, and I appreciate that. Despite giving Colin the exact same amount of notice for his original deposition, counsel for Reed declined to accept Colin's offer to be deposed on May 28th or 29th, 2026. Instead, counsel for Reed stated that the one lawyer Reed designated to take Colin's deposition, attorney Charles Waters, was out of state on those dates. Reed's counsel did not describe the circumstances of the designated lawyer's unavailability or explain why any one of the other 9 lawyers representing Miss Reed could not take Colin's deposition. You know why. Stop the games. Stop the game. Reed never identified whether attorneys Rosenberg, Segleson, or Jackson, who extensively questioned Colin during Reed's first criminal trial, were unavailable. Fair. Hold on. Can we're gonna do a brief little dance party. Because I have to go get something else to drink, and I have to go. I should have done this while Buffy was here, but I didn't. I'm gonna go get something else to drink, and I'm gonna do a quick potty break. So I'm gonna give you like a 3-minute dance party and dance meme party, if you guys don't mind, because I need something to drink. Where's my videos at? All right, and then I will be right back in. Wait, where'd all my videos go? Oh, there they are. Was it your first day, Llama? Come on. All right. Let's do number 8. How about that? No, let's do number 4. Feeling good with 4. All right. So I will be right back, friends. Okay. Dance party. Don't pull anything. Make sure you stretch. Okay. All right. I'll be right back, friends. Okay, and we're back. Look at that. I didn't want to, it was close to the end, so I didn't want to stop it. But thank you guys for letting me have a quick little break. I got me a Barg's root beer, which is my fave. It's also my son's fave. He drinks a lot of it. I have to hide them sometimes because I'm like, what are you doing? But funny thing is that when I was pregnant with him, root beer was like my drink of choice. Like I could not drink enough root beer. And now, guess what? He loves the root beer and drinks all my root beer. Oh, kids. He's my little root beer baby. All right. I hope you got a good dance party out of that. I got stuff to drink, ready to go. All right. That's right. She is a vet. Because could Buffy be any more badass? I don't think it's possible, quite frankly. Um, but yeah, all right. So where was I? I think down here. On May 21st, 2026, Colin's counsel also informed plaintiff's counsel regarding Colin's sudden availability issues. With no deposition scheduled prior to Colin's departure on May 22nd, 2026, the plaintiff served a subpoena on Colin through his counsel, commanding his attendance at a deposition on May 28th. Bound by the subpoena on May 28th, Mr. Albert was deposed, where he testified truthfully under oath regarding the events, of January 29th, 2022, in addition to other issues. Well, what other issues are there if he wasn't even there? It should have been like a 5-minute deposition then, right? Counsel for the plaintiffs, as well as counsel for C.F. McCarthy's questioned Colin, counsel for the Waterfall Bar and Grill was in attendance via Zoom, but did not ask any questions. None of the 10 lawyers for Ms. Reed chose to attend Colin's deposition, even though, upon the undersigned's information and belief, another witness deposition was previously scheduled for that day but canceled. Further, the deposition occurred in the same building as Feeney's office, but I don't know who that is. How are we supposed to know that? Hmm. All good. I'm glad you guys like the meme breaks. I need to make some new ones. I have tons that I still have to pull off my phone, but I haven't had to use them very much lately, so I don't know if you guys are over them and I need to make new ones or what. I never keep track. All right. So then the June 3rd, 2026 status conference, which we did watch, right? We did watch that one. Or is that the one that wasn't available? Go up here to June 3rd. No, we did listen to that one. Yes, we did. All right, there we go. During a June 3rd, 2026 status conference in this matter, counsel for Reed, attorney Rosenberg, accused the undersigned, as well as Colin, Brian, and Nicole Albert, the McCabe's, and Mr. Higgins of playing games with the wrongful death action discovery schedule. At no point prior to making the accusation to the court that these non parties were playing games did Reed's counsel undertake any effort to inquire about the schedules of these non parties or their counsel so that all parties could come to mutually agreed upon deposition dates. Indeed, it appears that this courtesy was only given to the other witnesses in this case. Oh my God, they're so catty. Come on. Did you laugh at those? Good. I'm glad you like them. Let's see, where was I? Moreover, during the same June 3rd status conference, counsel for Reed previewed this motion outside the presence of Collins' counsel, and in doing so, proffered to the court that, quote, Colin Albert refused to appear for a deposition and refused to produce documents. The trial channel, oh, shout out to the trial channel, which is where we watched these status conferences. The trial channel, O'Keefe v. Karen Reed civil status hearing June 3rd on YouTube with the link and the timestamp. As this opposition and supporting exhibits clearly demonstrate, that proposition made in open court into a live streamed audience of hundreds, it's thousands, was wholly and demonstrably untrue. Colin never refused to appear for a deposition. Ms. Reed's counsel canceled his original deposition. Then Collins sat for a deposition in this case on May 28th, 2026, and Reed's counsel refused to appear. Oh my goodness. Oh, you wanted to go into the Marines, but then you had a knee injury? Oh, that'll do it. That will do it. The patent misrepresentations regarding Colin refusing to appear for a deposition sparked immediate online attacks and defamation against Colin. Following that misrepresentation, Colin, as well as other non parties, were harassed, defamed, and ridiculed by dozens on various social media platforms, falsely claiming that Colin refused to appear for the deposition. This was entirely predictable. So, ridiculed by dozens on various social media, more than dozens, I'm sure. There are dozens of us, dozens. I watched that episode of Arrested Development the other night. Attempts to meet and confer to redress the June 3 misrepresentations. During the court's motion in the defamation action on June 4th, undersigned counsel sought to address the misrepresentations with the court. After the hearing, the undersigned initiated a meet and confer on this issue with Reed's counsel, attorney Seglison, explaining to Reed's counsel that the misrepresentation was serious, clearly contradictory to the record, and had sparked substantial public attacks on Colin, as if they don't put out their own public attacks all of the time on Karen. Like that's what annoys me about these people. It's like you do the same thing. All right, stop the games. I had a boss that used to say that all the time. Miss Debbie Jackson, stop the games. Should tell the servers. The following day, counsel for Colin reached out for an explanation and a willingness to see if Attorney Rosenberg was willing to retract or clarify his statements. Attorney Rosenberg indicated that he would evaluate the wording he used during the June 3rd hearing and let Colin's counsel know whether his statements needed clarification. Then on Saturday, June 5th, he filed unilaterally with the court a letter that did not correct the record, but rather continued to make misrepresentations. That pesky Rosenberg, always doing stuff like that. Now, here's her argument. Reed's motion fails to cite a single case, rule, or statute in support of its arguments. Instead, the motion relies on misleading and fabricated claims and is used as a mechanism to continue to harass Colin by impugning his character, impugning his character. Come on. The deposition subpoena is no longer void. Under Massachusetts law, a subpoena must command the witness to appear at a specified time and place. Thus, once that date passes without the deposition occurring, there is no longer any operative command to appear at a future deposition. The plain language of Rule 45 makes clear that a non party subpoena is not a continuing obligation unless it is reissued or amended to impose a new command. The original subpoena is functionally exhausted once the date contained therein lapses. Here, Reed's counsel never once inquired as to Colin's availability before serving him a deposition subpoena. Do you have to? Here's a quote from the Boston Bar. In scheduling depositions, reasonable consideration should be given to accommodating schedules of opposing lawyers and of the deponent. Okay. But that's from the bar and their standards. Despite this, Colin was ready, willing, and able to attend the April 29th deposition as scheduled. However, Reed's counsel unilaterally canceled the April 29th, 2026 deposition just days after Reed served the subpoena and never rescheduled it. He was willing, my friends. Willing. Oh, you wanted to be a cop, huh? Oh, look at that. No wonder you're so into true crime. I could never be a cop or a detective. I couldn't do it. It's a tough job. It's a very tough job. Let's see. He was willing and able. Blah, blah, blah. In canceling the deposition, Reed's counsel cited the parties' ongoing dispute regarding the scope of the document subpoena. But the motion ignores the fact that Reed could have taken Colin's deposition on April 29th and continued it to a later date, pending the deposition of that dispute. Reed's counsel chose not to do so and failed to reissue a deposition subpoena on Colin for a different date. Excuse me. Plaintiff's counsel thereafter issued their own subpoena, commanding Colin to attend a deposition, and Colin appeared for said deposition on May 28th, 2026. The only party in this action that did not appear at the deposition was Reed. Reed's counsel cites no authority justifying this conduct, much less any authority that would support an order commanding Colin to attend a deposition on a date and time that has lapsed. Oh, damn. I did not know that. I didn't know the IRA was still like a big thing over there. The more you know. We don't hear about it over here. So I apologize for being wrong about that. We don't get news. I didn't realize it was still a thing. Huh. Interesting. I'll have to look into it then. Thank you, Liz. To the extent Reed challenges the procedural soundness of plaintiff's May 22nd, 2026 subpoena, that issue is between the plaintiffs and Reed and cannot serve as a basis to grant the instant motion. These concerns are properly raised in a motion for summary judgment. Colin's legitimate scheduling issues were promptly relayed to Reed's counsel. Instead of working with the undersigned in good faith to complete Colin's deposition before he enlisted in the U.S. Army, Reed's counsel instead chose to engage in litigation tactics by filing this instant motion. The court should not entertain such subterfuge. The document subpoena is overly broad and unduly burdensome. 21 pages to say all this shit. It's crazy. Massachusetts Rule of Civil Procedure 45 authorizes the issuances of subpoena to non-parties, but the authority is not unlimited. Under Rule 45D1, the court shall protect a person who is neither a party nor a party's officer from undue burden or expense. Subpoenas are subject to supervision by the presiding judge to prevent oppressive, unnecessary, irrelevant, and other improper inquiry and investigation. To be proper, a subpoena must describe the documents sought with reasonable particularity. Ms. Reed's subpoena violates these standards in several critical aspects. Her request A through F each demand that all documents, including communications relating to a named person or broadly defined topic, Karen Reed, John O'Keefe, Michael Proctor, the investigation, criminal trials, and the civil actions, these categories are defined in the broadest possible terms. The defined term investigation encompasses any investigation concerning the death of Officer O'Keefe conducted by the Massachusetts State Police, Town of Canton Police, Norfolk District Attorney's Office, and or any other law enforcement agency. The defined term civil actions sweeps in both the instant wrongful death action and a separate federal civil rights action filed by Reed. These requests contain no temporal limitation whatsoever, effectively demanding every document Colin has ever possessed relating to any of these topics. But aren't you saying that he doesn't have any? He just has one text. That's it in this story. And that's what you've been saying for the last 15 pages. So, okay. Requests G through I demand all communications with Michael Proctor, John O'Keefe, and Paul O'Keefe, again, with no temporal limitation and no subject matter restriction. A request for literally all communications ever exchanged between the two individuals regardless of topics, is the epitome of overbreadth. Moreover, Colin has already made a good faith representation to Reed's counsel that he is not in possession of any communications with Michael Proctor. Request J demands all communications from January 28, 2022 to the present, a period spanning more than 4 years, with 12 named individuals, including Colin's own parents, aunts, and uncles. This request would require Colin to produce every text message, email, and communication he has exchanged with his own family members for over 4 years, regardless of whether those communications have any connection to this litigation. But here's the thing is have you read them all to know if they are relevant or not? Also, it's not I don't think it's that hard for them to show up. I mean, just saying. Is it that much of a burden? I don't know. The breadth of these they need to learn a new word. The breadth of these requests is particularly inappropriate given that they are directed at a non-party. Colin has no real connection to this litigation. He is not a defendant. He has not been accused of any wrongdoing in this wrongful death action. It reminds me of that scene and meme from Parks and Rec with uh, John Ralphio and Mona Lisa's dad. And they're like, they have never done anything wrong ever in their lives. They would never, you know what I'm talking about. He has already provided testimony. Reed has failed to sufficiently establish the relevance that Colin has to the wrongful death action, despite counsel's multiple attempts to understand it. Indeed, when asked what basis Reed has to believe that Colin was responsible for the death of Officer O'Keefe on April 28th, 2026, at the 9C conference with Colin's counsel, Reed's counsel refused to provide any detail. Okay. The motion itself acknowledges Colin's testimony that he left 34 Fairview prior to the arrival of Reed and Officer O'Keefe. Colin has testified to the fact under oath on 3 separate occasions, including in his deposition in this case, which Reed's team did not attend, and now submits an affidavit attesting to the same. Why didn't you mention his testimony under oath at the trial? But okay, right. I've never done anything wrong in my entire life. Money, please. It's one of my favorites. My favorite gifts to use. Reed's baseless accusations that Colin has violent tendencies and that Colin and Mr. O'Keefe had a series of prior disputes are entirely unfounded, illustrated by the motion's failure to cite to any evidence in their support. Indeed, had Reed's counsel attended Colin's deposition in this matter, they would have learned that Colin and Mr. O'Keefe barely had any relationship at all, and that Colin certainly never harbored any animus towards Mr. O'Keefe. Moreover, the allegations, which are again unsupported, regarding a photograph of Colin with scabs on his knuckles ignores entirely the evidence admitted during Reed's first trials of Colin appearing in photographs after the death of Officer O'Keefe, but before the photograph showing scabs on his knuckles with his hands entirely unharmed. So they're saying those February pictures we saw were before the scabbed hand ones. Okay. Ugh. See, that's what I said, Lainey. I thought that too. But we don't get this news over in the Americas. Wow. Holy shitballs. At his kid's soccer game? Whoa. All right. I will be looking into all of that. That is wild. My goodness. Okay. Guess I'll look into all of that again. Moreover, oh wait, I'm sorry. I already read those, which is hands on harm. Notably, the document subpoena does not seek photographs of Colin following the death of Officer O'Keefe because Reed knows that such photos would undermine her fantasy regarding Colin's involvement in Officer O'Keefe's death. Well, are you willing to send those over? Just wondering. Be like, here you go. Is that what you guys are doing? On its face, the subpoena treats Colin as though he were a party to the case, or worse, as though he were a target of investigation, and demands a comprehensive accounting of his entire private life. These assertions lack any basis in fact. Indeed, during her second criminal trial, in which significant latitude is afforded to a criminal defendant, Reed was expressly barred by the court from arguing a third party culprit theory with respect to Colin. That is true. In any event, but just because you're barred doesn't mean it couldn't happen. You just weren't allowed to be like, yeah, this is our defense. Excuse me. In any event, the motion provides no basis upon which Reed would be entitled to such an extraordinary, excuse me, an invasive trench of discovery against a third party. Also, Barb's root beer makes me very burpy, and you know Llama burps a lot, so there's that. Reed should not be permitted to use her subpoena power in this action as a covert means of obtaining a relevant discovery from a non party solely to impugn that non party's character and reputation. I wonder, because we have not read all the documents in the other cases that Colin has mentioned in, like if they're the same in that, right? Because in her federal one, I think he is listed as a defendant in that one. So, okay. Moreover, Reed's own proposed narrowing demonstrates the overbreadth of the original subpoena. Even after purporting to narrow the request, Reed continued to demand all documents, including communications relating to the same broad categories that we just went over, and merely adjusted one subcategory of request J relating to Colin's parents. A narrowing that leaves intact requests for all documents related to 6 overbroad topics is no narrowing at all. This subpoena illustrates precisely the type of burden from which Rule 45 is designed to protect. But if there is nothing, then how is there a burden? I don't understand. But okay. Like, at least with the other people who are claiming undue burdens, like the cops and all of that and state, they do have millions and millions of pages of documents, as we learned. So yeah, that is a lot to go through. But come on. I think they're being a little ridiculous here, especially when they say there's nothing there. So which is it? It's either a lot to go through or it's nothing. Let's see. We love a gassy queen. Yes, yes, we do. And that's me. For years, Colin and others have been subject to outrageous abuse for no reason other than his willingness to cooperate in a law enforcement investigation into the death of Officer John O'Keefe. And this is something for those of you that did not watch the trials. So apparently, like some of them in the house knew John, some didn't really know him very well, right? But the way that they talk about him is very cold, like, even right after his death, like, it's as if nobody knew this guy and doesn't even really care. It's weird. It's very, very, very weird. You guys will see when we rewatch some of the testimony. Um, that abuse has included defamation and misinformation that has been publicized by Reed and her attorneys in a judicial forum. Indeed, Professional Rule of Conduct 3.3A1 provides that a lawyer shall not knowingly make a false statement of fact or law to a tribunal. This duty of candor is among the most fundamental obligations an attorney owes to the court and to the administration of justice, which we have seen them file duty of candor or notice of candor in the Laura Owens cases. So it does get filed, but all right. The rule recognizes that the integrity of judicial proceedings depends upon the truthfulness of representations made by counsel, and that the courts are entitled to rely upon these representations in making decisions that affect the rights of litigants. Courts possess inherent authority to impose sanctions for conduct that abuses the judicial process, including the making of false representations to the tribunal. So they're throwing like, well, I think maybe they should get sanctions for all this. Further misrepresentations by counsel in a case such as this will have a profound impact on various non-party witnesses, including Colin, because they are immediately relied upon and used by online purveyors of lies who have adopted Reed's baseless claims and used them to torment and harass those witnesses. All right, many of us came to our own fucking conclusions based by the case that the state put on, which was garbage, and all of the other bullshit going on. I don't know what to tell you. All right. Now, no, you shouldn't torment and harass anybody. I didn't do that. But there are reasons why so many people were into this case is because of the bullshit that encompasses it. And it really does amaze me, some of their arguments. It's like, did any of you watch do you realize what all has happened in this trial? And you want to sit there and be like, I don't know why you guys don't just believe them. You should just believe them. Listen, I have watched so many fucking trials, so many. And not a single one have I ever watched where just about every single person that took the stand for the state was weird on the stand. Weird, being kind of secretive and defensive. I mean, even the EMT, the first responders, who are like, in most trials, the least, like, you don't even question what they're saying at all. Even they, in this one, you were like, why are you being weird about things? Why are you like, it's crazy. But we're all wrong. It's just them gaslighting everybody. The only people that are right about this are the House defendants and the state, who spent millions of dollars to prosecute this case 2 times, and the investigators, where we have seen the shit the investigators were up to. But you're right, it's all us. It's all of us coming to these crazy conclusions and falling for the conspiracy. Okay. Right. How many officers involved in this case no longer have their jobs? Quite a few. More than there should be for a case like this. That's for damn sure. A smear campaign. Exactly. Ugh. Ugh. You have to jet. Bye, Rachel. Have a good day. I'll see you tomorrow, babes. Though, yeah, Travis Rudolph was a good one, but they did not compare to Reed at all. It's wild. But sure, this is all the internet getting into a conspiracy, and what we saw and took in with our own eyes is wild. And um it's also weird, half-ass. It's also weird that someone who calls themselves Turtle Boy is credible. That's true. But I mean, I don't really listen to Turtle Boy. I didn't really know. I didn't follow any of this case before the second trial started. Like, I did not watch the first trial. I was not up to date on things. I did not watch him on YouTube. I kind of pretty much went into Reed not knowing anything about it compared to everybody else. So, I certainly was never influenced by anything that Karen or Turtle Boy may have or may not have put out on the internet. It was very easy for me to come to my own conclusions about all this. So, yeah, he's Dr. Turtle Boy. I'm sorry. I apologize. Dr. Turtle Boy. But it's just crazy that It's going on like this. I'm wondering how many years of Karen's life this has taken up. Well, let's see. When did it happen? 2022, January of 2022. It's now 2026. She is now in two other. Let me pull up real quick the ones that were just filed. So this trial that we're just watching or reading about now, O'Keefe, the wrongful death one, is slated to have go to trial next springtime ish, probably between their last pretrial date, which I think is in February, and then I want to say the judgment date is like August 28th of next year. I'm going to go with they're probably going to have a spring trial, like April, May. That seems to be her lucky time to have trials. Let me see when they say the date is going to be for Ham. Uh, let's see. And you can find all of this stuff on the masscourts.org website if you want. Make sure when you go to search cases, you have to select the Superior Court, and then you want to pick the Plymouth County as the court division. Okay. And you can see the wrongful death one and the Ham defamation one there. The other ones, one is in, I think I used the court listener for the federal one, and the cop, what's the cop one? What place is that in? There's so many. They start in one county. Oh, Bristol Superior Court is where the Reed v. MSP in Canton is. Anyway, sorry, I was looking up there what they call the tickler, which is when certain things are supposed to be done by. So they're for Ham, the final pretrial conference they have scheduled for June 30th of 2027, with a judgment being March 17th, 2028. So that that would probably mean that the trial would be, I don't know, maybe January. Who knows if the judgment, because you're going to want to give the judge maybe like a month to write something, I guess. I don't know. We'll see. But those are the dates they have for now. Will they stay? Who knows? Who knows? Okay, my microphone or my headset shut off probably because I'm by myself. So it's like, I thought I turned off. His stream one day ago says 3 months until trial. Whose? Um, he's going by Turtle Dove. That's really funny. I like that. Anyway, back to this. It is for this reason. Oh, Turtle Boy said. Oh, I'm misreading. His stream one day ago says 3 months until trial for the O'Keefe one. He has so many different cases right now. I'm waiting on a list of them all so I can then go and find all of the things. So, oh, interesting. Hopefully not the same time as Murdoch. Girl, I hope not. Otherwise, Llama isn't sleeping for like 2 months straight. So, okay. Also, if any of you know where I can find all of the lawsuits, if there's like a list somewhere for Turtle Boy, I would greatly appreciate that. He has criminal cases and civil cases, and I just want to make sure I get them all in one place because it was hard enough to find these four in like the right, place for things. So, oh, there's Elbow Fee. Hi. What are you yang me about? Not sleeping for 2 months? 3, what is that? Episode 901, 3 more months until trial. Okay. Well, then I guess I'll be it was on for 4 hours and 20 minutes. Nice. I guess I'll be watching that this evening then. I don't get to catch a lot of his stuff because the time does not line up with my time. So interesting. 3 months from now is when? November? For the ham one? Okay. All right. We'll see what happens. Anyway, let's get back to this because I still got several more pages and whatnot. So, Elfie, are you on your way home yet? Just wondering. Torment harass. It is for this reason that the court should treat such misstatements, especially those that are endlessly parroted against the various non party witnesses, very seriously. As detailed below, counsel's collegial efforts to convey this concern to Reed's counsel was met by indignation, followed by the submission of a convoluted and misleading letter to the court that only compounded the harm. Oh my God, that is such Laura phrasing right there. Here, the misrepresentation by Reed's counsel to this court during the June 3rd, 2026 status conference undoubtedly violated Rule 3.3. First, the statement was false. Colin did not refuse to appear for his deposition. The email correspondence attached here too confirms that Reed team canceled the deposition and never rescheduled it. Second, the falsity was known to Reed's counsel at the time he made the statement. Colin did not refuse to appear for Reed's deposition. Reed's counsel canceled the deposition just 6 days after the subpoena was served on Colin. Colin was available and prepared to appear in response to Reed's deposition subpoena on the notice date. Third, the statement was material. Reed's counsel made the statement to the court in connection with this motion that was served but not filed, made the statement outside the presence of opposing third party counsel, and made the statement to persuade the court that Colin was engaged in obstructive conduct, thereby prejudicing this court and the public against Colin in anticipation of the filing of Reed's motion. Let's see. Do we want to watch? Well, tomorrow, do we want to watch the 2 hearings, the motions to compel Colin, or hold on, let me look at my schedule. Do I have something going on tomorrow or Thursday? I feel like I do. We're eventually going to get through this. Oh, no, that's right. I don't. Okay, so it doesn't really matter. Never mind. I forgot we're not doing a documentary review tomorrow evening for True Crime and Wine Time over there. So we can go longer the next 2 days. So it doesn't matter. Never mind. After the issue was initially raised following the June 4th, 2026 hearing in the defamation case, counsel for Colin tried to confer with Reed's counsel regarding this issue to see if the parties could reach an agreement on a corrective filing. Indeed, it was counsel's expectation that if Reed's counsel's misstatement had been inadvertent or careless, Reed's counsel would appreciate the harm that such a statement was likely to cause and voluntarily correct it. So they're like, we thought we were going to get an apology, and we didn't. And Rosenberg is mean. Instead, Reed's counsel responded with personal criticism directed towards opposing counsel and continued his assertions that the same was playing games to avoid Colin's deposition. Oh my goodness. Clutch your pearls harder. How dare he? While Reed's counsel ultimately agreed that his statement that Colin refused to appear for a deposition was somewhat inartful in context and stated his willingness to clarify the record with the court, he failed to do so. I don't think we believe him. I think he was lying to us, Your Honor. All right? It was not in good faith that he said this. Instead, despite counsel's effort to further the meet and confer process on the issue, Reed's counsel unilaterally submitted an ex parte letter that merely provided the court with a narrative of his position regarding the April 21st subpoena prior to the court's consideration of Reed's instant motion. Instead of offering a plain, candid, and professional acknowledgement that his public accusation against Colin was incorrect, Reed's counsel's letter took additional swipes at Colin by confusingly suggesting that he had been referring to broad discovery disputes. This did not remedy the harm, but compounded it. The plain meaning of the words refused to appear communicated to the court and the public that Colin affirmatively declined to attend his deposition. This is how any reasonable listener would interpret those words. That is how members of the public understood the statement following the hearing, and that is precisely why Colin's counsel sought clarification. Reed's counsel post hoc explanation that he was actually referring to a series of future scheduling and document production disputes only underscores that his original statement was misleading. A dispute over document production or future scheduling is in no way means Colin refused to appear. My God, you're going on about this for 19 pages, front and back. What are you, Ross? Or Rachel? I forgot Rachel's the one that wrote the letter. 18, wasn't it 18 pages front and back? Oh, yeah. The harm following from the misrepresentation has been substantial. How? Isn't he supposed to be at fucking boot camp? He doesn't have access to the phone or the internet or whatever, so how is this affecting him in any way? He's supposed to be at boot camp on June 12th, 2026, but okay. Colin has been subjected to a campaign of online harassment and intimidation that was sparked directly by Reed's counsel's false statements in open court. Indeed, in the hours and days that followed the June 3rd status conference, disturbing comments were publicly made in direct response to Attorney Rosenberg's misrepresentation, including that Colin made the decision to serve his country in order to flee his deposition in this case, and that such decision meant Colin, quote, can kill legally, end quote. You can't say what sorry, nobody has control of what people say on the internet. All right, people say dumb shit on the internet all of the time. They leave dumbass comments on our stuff or make dumbass streams about it. I don't know. People are going to say crazy shit on the internet. Has this lawyer ever been on the internet in the last several years regarding this case? But also, okay. Other comments made immediately following the status conference included that Colin was complicit in murder and accused Colin of dodging a deposition with Olympic level agility. But he shouldn't have seen any of this, by the way. Was it sent to Colin? No, it's just the internet talking shit. Welcome to 2026, my friend. Even after counsel put Reed on notice of her counsel's Rule 3.3a violation and attempted to meet and confer regarding a potential resolution, Reed's counsel nevertheless continued to project the false narrative that Colin refused to appear for a deposition. For example, on June 5th, 2026, during Reed's recent media campaign, attorney Alan Jackson appeared on podcaster Billy Bush's YouTube show, wherein he discussed the issues pertaining to Colin's deposition. On that show, attorney Jackson stated that Colin has not been deposed yet, accused the undersigned, me, of engaging in shenanigans and playing a few games, and alluded that the Reed team intended to reissue a deposition subpoena on Colin, notwithstanding his recent enlistment in the U.S. Army. This guy is obsessed obsessed. I cannot wait to read these Ham v. Reed Turtle Boy documents now. This guy, whew, wow. Wow. Okay. Does he know that he's representing probably some of the most hated people on the internet? There's Kelly. AJ look fire on the interview. I think I remember watching that. The internet is so mean. Make them stop saying mean things that no one really has control over. But for any of the foregoing reasons, the court should exercise its inherent authority and deny the instant motion because of Reed's counsel's rules violations. Conclusion. Had Reed's counsel engaged in good faith to reach a reasonable consensus regarding the subpoena, this motion practice would have been unnecessary. They refused to do so. Instead, they offered Colin hollow compromises, which were indeed not compromises at all, refused to coordinate their schedules to accommodate his recent and commendable career change, and subsequently made entirely false misrepresentations in court. Contrary to Reed's accusations, the only one engaged in gamemanship here appears to be her. Jeez. Ooh, okay. For the foregoing reasons, the motion should be denied in its entirety, and the court should grant any further relief deemed just and improper. Okay, so this was from the 9th that they filed it. All right, but it's on my 12th. So, because that's Karen's team put all of these together and filed them on the 12th. That's why. Okay. So you did just get here then. Oh, you're talking to Lig. I see the next message. I just thought you meant the lawyers, but it does seem like the lawyers just got here too. Like, yikes. Do you know who you're talking to? Also, I mean, listen, Colin going into the army seems weird. Seems very, very weird. Very, very weird. And, some people like to use the whole, well, you're a veteran or you're active duty, bless you, and just think that it absolves them from doing any sort of harm ever. They like hide behind it. And I don't think that really works in court, like at all. When it's used inappropriately. Like, yes, it can lead a lot of credence into, um, like perhaps truthfulness or something like that. But even then, hey, assholes serve in the military too. Okay. And when one is, possibly doing some crazy shit, I don't think it should protect you in that sense at all. Just like, bad cops. So you're supposed to be in bed, but having too much fun. It's 9:40. You're fine. We won't tell anybody. All right. So let's see. Then we go to page 30. And what do we got here? We got, what is this? Oh, Colin's affidavit. All right. So here's Colin's affidavit. This will come in handy later. I, Colin Albert, on oath. Wait, when does this have a date on it? No. But look, it looks like front and back. I, Colin Albert, on oath, hereby depose and state as follows. 1, I am not a party in this lawsuit. Everything I say in this affidavit is based on my own personal knowledge. If it's front and back, that's more than he had to say in the trial. That for some reason took 2 hours for him to testify, but okay. And he's like, I got 3 pages. So, all right. On the evening of January 28th, 2022, I went to my aunt and uncle's house at 34 Fairview Road in Canton, Massachusetts. I was there to celebrate my cousin Brian Albert Jr.'s birthday. I arrived at 34 Fairview at about 10 p.m. At around 11:55 p.m. on January 28th, I texted my cousin Allie McCabe to see if she would pick me up from 34 Fairview. How'd he get there? I don't remember how he got there in the first place. She texted back that she could, but had to drop off other people first. At around 12:10 a.m. on January 29th, 2022, Allie McCabe picked me up from 34 Fairview. Allie dropped me off at home about 5 to 10 minutes after picking me up from 34 Fairview. I stayed home for the rest of the night. I testified before a federal grand jury regarding the investigation into the death of John O'Keefe. I also testified at the first of 2 criminal trials against Karen Reed. 9. On April 21st, 2026, I was served with a subpoena from Karen Reed. The subpoena told me to turn over certain documents by April 27th, 2026, and to show up for a deposition on April 29th, 2026 in this case. I was ready and willing to sit for that deposition on April 29th, 2026. However, my lawyers told me that Karen Reed's lawyers canceled the deposition and never rescheduled it. On May 19th, 2026, I let my lawyers know that I might have to leave the Massachusetts area for a long time because of work. So he still doesn't even drop in the whole going into the military thing, but okay. On May 20th, 2026, I told my lawyers that it was confirmed that I needed to leave the Massachusetts area for work starting on June 2nd, 2026. I also told them that I would be away until at least September 2026 and would have very limited access to my phone or email during that time. Right? Did he actually go through? Is he in basic training now? Do we know if he went through that or not? But he used to live in Rhode Island. I don't think I knew that, Liz. Maybe I did. I don't know. On May 22nd, 2026, my lawyers told me that they accepted a subpoena from the plaintiffs in this case, which required me to show up for a deposition on May 28th, 2026. On May 28th, I went to Hinckley, Allen, and Snyder in Boston, Massachusetts for a deposition. I was questioned in person by attorney Diller, who represents the plaintiffs, and attorney Tamara Smith Halstag, who represents C.F. McCarthy's, attorney Casey McCaffrey, who represented the Waterfall, attended by Zoom but did not ask me any questions. As for the documents that Karen Reed's subpoena asked for, shortly after I got the subpoena, my lawyers asked me to find certain communications that I might have. First, I checked whether I have ever had any communications on my phone with the people listed in the subpoena. I confirmed that I have never had the phone numbers for Michael Proctor, John O'Keefe, or Yuri Buchanan on my phone. So I don't have any communications with any of them about anything. Okay. How did they contact you then to tell you to come in for questioning a year and a half later? Just wondering. Next, for the people whose phone numbers I do have, I checked to see if I had any text conversations with them around January 28th, 2022, about John O'Keefe's death or the investigation into his death. To do this, I scrolled back through each text thread I have with those people to January 28th, 2022, and looked through whatever conversations I had with them around that time. I also used the search feature in my iMessage app to search all of my text messages for certain keywords that would turn up conversations about John O'Keefe's death or the investigation into his death. The keywords I searched included Karen Reed, John O'Keefe, Michael Proctor, O'Keefe Proctor, and investigation. Well, it doesn't mean there's not things in there just because you didn't use those words exactly, but you'll see when we watch Colin's testimony, he is not the brightest bulb in the box. Okay. I also used the search feature in my iMessage. Oh, wait, I read that one. After doing all of that, with one exception, I did not find any communications about anyone listed in the subpoena about John O'Keefe's death or the investigation into his death. You know what word he didn't search? Cop. Just saying. I have to get creative with searches when I'm doing, cases and stuff. You have to get very, very creative. I didn't think cop, all of those sorts of things, but okay. The one exception was a text conversation that I had on January 28th and 29th with my cousin, Allie McCabe. In those texts, I was talking with Allie about picking me up from 34 Fairview. The text shows that Allie picked me up from 34 Fairview at 12:10 a.m. on January 29th. I have gotten new iPhones since January 29th, 2022, but every time I upgraded, I transferred all of my data from the old phone to the new one. Oh boy. Thanks for letting them know that. 23. I never saw Karen Reed, John O'Keefe, or Karen Reed's car at any point on January 28th and 29th, 2022. And there's his signature, I guess. So, okay, that makes sense. Let's see. All right. So then we have here's the text between him and Allie. At 12:17, I guess that was a different day. Oh, a different night. Haha, Mikey's making me shotgun, so he's going to be in the blue. Allie is going to be in the gray. January 28th at 11:54, you can come get me now if easier. And she says, okay, I'm driving people home now. Word, get me after. And she's like, KK, here. Okay. And then that's that, I guess. I mean, also it's just like, okay, here. I mean, I don't know. I don't know if it really says a whole lot. I feel like there was more into it though. Oh, yeah. We're gonna have to rewatch this testimony again. Because isn't there stuff that happens afterwards that doesn't I know for Allie it does, but I feel like there was some other stuff going on with Colin in his phone afterwards, but I don't remember. On February 20th on a Zoom. Are you going to Will's? Let's go. It's your birthday. We are drinking. Remember, he's only 17. Um, so I have a feeling that there's probably also stuff in there about his phone that is was illegal, I suppose. All right, so there's that, and then here is the police report from Buchanan to Tully. And this is October 17th, 2023. So a whole well over a year and a half after 2022. Yes, afterwards. So he says on Monday, October 16th, 2023, at approximately 1 p.m., Lieutenant Fanning and I were able to interview Stephen Richard Scanlon during a pre scheduled time, which I set up through his attorney, Tim Flattery. The interview took place at the Norfolk District Attorney's Office located in Canton. Upon their arrival, I directed Mr. Flattery and Mr. Scanlon to the community room, which is where the meeting was held. Following brief instructions, we asked Stephen if in or around February 2022, he reached out to Attorney Yannetti over the phone or had he visited his law offices as it related to the O'Keefe homicide out in Canton. Oh, it's going to cut off there. Shift. There we go. Stephen stated that he initially reached out to Karen Reed over Facebook Messenger and told her that he was a private investigator and would be willing to put another set of eyes on the investigation, even mentioning that he would do it free of charge. Karen Reed recommended that Steve contact her attorney, David Yannetti. Stephen stated that he was not sure of the exact date, but that he eventually called Yannetti's office and offered the same services, suggesting that O'Keefe might have been beaten up and that he was not sure what happened, but would be willing to work on the case. Obviously, only if agreed on by Yannetti and his client, Karen Reed. Following their phone conversation, David Yannetti asked Stephen to come into the office to further discuss the matter, which Stephen did back in early 2022. Okay. Stephen went on to say, excuse me, that during his visit to Yannetti's office, there was another individual present during their meeting. Stephen identified the male party as Paul Mikowski. There we go. We looked him up earlier, who is also a private investigator in Massachusetts, and the two had crossed paths in the past year. During that meeting, Stephen was asked if he knew Colin Albert and an ATF agent, both of whom were allegedly in the home during the evening hours when O'Keefe was killed. According to Stephen, this was the first time he had heard of Colin Albert and an ATF agent being possibly involved in the matter, and both had been mentioned by Mikowski and Yannetti. Prior to the meeting concluding, Stephen stated that Yannetti handed him a check for $1,200 to $1,500 and asked him to keep his eyes and ears open in the Canton area in regards to the O'Keefe case. Okay, why did he hand him money then? Although Stephen took the check, he consulted with his attorney, Tim Flattery, and returned it back to Yannetti since he was not working on the case and he further felt it would be a conflict of interest. Right. Okay. In days and weeks following their meeting, Stephen was in communication with an individual named Jack Hollow. Mr. Hollow, according to Stephen, is a mutual friend of both Stephen and Mikowski and used to do work with Brian Albert. Hollow shared information which he had learned from Mikowski. That information being that Yannetti and his team were looking into Colin Albert and the ATF agent since Colin allegedly had beef with O'Keefe. I asked Stephen how come he did not reach out to investigators when he learned this information, to which he stated that everything he had learned was fourth, fifth, or even sixth person removed from the source. Thus, he did not think that it was credible or important to reach out to us at the time. Oh, so we're going to blame this on him? Okay. Right. At this point, Stephen circled back about an event he had mentioned earlier in our conversation. Excuse me. Stephen had told us that he was at Patty's Irish Pub in Newton for lunch one of these days following the homicide taking place, and the local news was broadcasting coverage of the case. He sparked up a conversation on the matter with the bartender, who told him that she lives in the neighborhood where O'Keefe was found, and that days following the investigation, she received a call from an unknown party telling her that the police were looking for ring camera footage and not to release it to the authorities. Stephen didn't know the bartender and only provided a physical description of the female and her approximate age being in the 30s. Stephen told us that he also shared this information with Mikowski and Yannetti during their meeting as well. Stephen once again reiterated that he told Yannetti and Mikowski that his opinion and theory was that O'Keefe looked like he could have been beaten up, but he had no personal knowledge of what actually happened or who could have been involved in the murder. The name Colin Albert and the ATF agent were mentioned by Yannetti and Mikowski in the meeting and not Stephen. Why is he not dropping Higgins' name? They know Higgins was there. It's weird. That's all I'm saying. We asked when was the last time he spoke to Brian Albert, since the two used to work together. Hi, honey. Stephen told us that he last spoke to Brian in April of this year and that he considers Brian a friend. Oh, okay. Stephen told us he knows both Brian and his wife. He has also met Chris Albert and Kevin Albert at Brian's house years prior. Stephen estimated it to be around 1998 to 2001, during the time when Brian was in a bad car crash and Stephen would stop by the house to check in on Brian. Stephen was asked if he had ever had a phone conversation with Aidan Kearney and whether or not the conversation was recorded by either of them, and if so, was Stephen advised by Kearney about the recording? Stephen stated that in approximately June of 2023, he spoke with Turtle Boy following a Saturday Night Live show that Aidan Kearney does on YouTube. The following morning, Sunday, after the show, during the episode where Kearney mentioned Stephen by name and his alleged connection to the case, Stephen woke up to a Facebook message from Aiden stating something along the lines of tick tock, you should call me. You shouldn't be scared of Brian Albert, and you should be scared of me. Stephen told us he asked Kearney for his number and called him. Prior to talking with Kearney, Stephen told us he stated, "Before I speak to you any further, is this being recorded?" To which Kearney stated, "Absolutely not. That would be illegal." During their conversation, Stephen told Aiden that he did not know Colin or the ATF agent in question, and he didn't know anything. Sorry, my headphones shut up again. Where was I? Aiden told Stephen in question, and he didn't know anything about the case. Aiden told Stephen that he was not talking to the defense, but to close friends of Karen's, and that is where he is getting his information. Stephen told us that he suspected that Yannetti was feeding Aiden his information on the case and the investigation. Okay. Stephen recalled sitting on the beach during the summer of 2023 with when a friend of his, Irish Ray, who is also a retired private investigator, contacted Stephen and told him that a recording of Aiden and Stephen's phone conversation was shared online by Aiden. This was the same conversation that Aiden assured Stephen was not being recorded. Stephen went on saying how upset he was about Aiden recording him without his consent, especially after promising him he would not do such a thing. Stephen had to fight back tears as he told us how upsetting it was to have Aiden drag his daughter into this mess as well. What does his daughter have to do with anything? I don't know this story. So Stephen told us that Aiden told him to call a 401 area code number that Sunday morning, which is the line that their conversation was held on and at the same time recorded. Okay. And by the way, Massachusetts is a two-party consent state, in case you didn't know that. So that means both parties have to agree to being recorded. But I don't know the truth of it. I know very little of Turtle Boys, like history through all the things. We were further told by Stephen that Gretchen Voss of the Boston Magazine publication had reached out to him for comment on a story she published, but he never returned her calls. Stephen once again told us that his theory was all based on his opinion and the media reports, and that he himself had no personal knowledge of the O'Keefe incident. Additionally, Stephen never spoke to anyone involved in this case, so he would not have had any insider information either. At this point, Stephen's attorney, Mr. Flattery, jumped in and stated that as a result of Aiden's blogs and YouTube live shows, there had been a significant impact on Stephen and his livelihood due to the publicity generated by Aiden. Stephen is losing work as a result, and it is impacting his reputation in the professional field and on personal levels. Okay, right. Elafite says, so if a person from a one-party state secretly records a call from a person in a two-party state, is that a crime? I don't think so, because it's who initiates the phone call, I think is where the law, it's the origin of the phone call, I think has jurisdiction there, but I don't, that's a good question. But I think that's how it goes. I don't know. Why don't you look it up and you come tell me? You are literally in the next room over, sir. I'm just kidding. I think it's where the call begins from. So, are you implying that maybe the number he called was an out of state number, therefore making it actually legally to be recorded? Or I don't know. All right. Without having anything further to add, we thanked both Stephen and Mr. Flattery for their time and concluded the interview. Okay. Well, that's great. All right. So now we skip a bunch of stuff because it's all stuff that's been filed before. Oh, I got some emails. 97. But I'm gonna like not show them to you guys. So sorry. Oh, Shihan, that's where Rosenberg works. That's the name of they mentioned it earlier, and I was like, who the fuck is that? It's just the name of their firm. All right, so we got some emails back and forth here. Are these in order or is it gonna suck? Yep, they're not in order. Of course. Thanks a lot, Kieran. June 5th, 9. Mm. Okay, yeah, we gotta go all the way to 103. Okay, yeah. All right, from the bottom to the top. Mhm. All right, so it starts off with, make sure this is all right here. Yes, okay. It looks like an email from Diller, because why not? So, Mark Diller for the plaintiffs. Bye, Liz. Hope you have a good night. Thanks for being here. Hopefully I'll see you tomorrow. Can we do this so that way it's not super just me tiny. Oh, if he says like Ohio is one party, I should be allowed to record any conversation without notice of the other party to any conversation I have while I'm in this state. That's what I think, but I don't know. Google it. Google it, I guess. So, but I don't know. That's a really good. I don't know the answer to that. I think it. Huh? Why are you yelling at me from the other room? Isn't this the stuff you spend all your time watching on the YouTubes, babes? A Turtle accidentally uploaded the Scanlan recording to YouTube, so we know it exists. There's also a recording of Lucky. Okay. What's your? I know. So what's your? It's not very specific.
This is a very specific question.
I know. I was wondering if you had a very specific answer. Like you have Google right there. We got an elbow feet crash in the stream. Let's see. All right. So what does it have to say, babe? So much lying. All right. So while he's doing that, let's read this email from Mark Diller on Friday, May 22nd, 2026. Counsel, please note the following. Tuesday's deposition. Oh, we've already actually read this one. That was about the one being canceled, Ms. Bombardier. We read that email already. Did we already read all these? Okay, we read those two. We'll start here. This one is from Kieran Murphy. What's his name? Colin. I keep wanting to say Clayton, and I'm like, don't do it. Colin's attorney to Damon Reed's and Olive Reed's team. Hi, Damon. I understand that you spoke with Jim today about the misrepresentations made by Aaron in open court during yesterday's wrongful death status conference regarding the facts surrounding Colin Albert's deposition and document subpoena. Please advise as soon as possible whether Aaron or another member of your team intends to retract or clarify those statements with Judge Gilday. Otherwise, we intend to cross-move for sanctions against Aaron for violating Rule of Professional Conduct 3.3a when serving our opposition to the outstanding motion to compel tomorrow. I look forward from hearing from you, Karen. Do you? Oh, I'm sorry. Thanks, Kieran. Then Aaron, I'm sorry. Okay, so Murphy sends that Thursday, June 4th at 4:40 p.m. At 4:45 that same day, Aaron sends an email back. All it says is, "You guys are really something else. What misrepresentations?" Might help to lay out what you allege to be misrepresentations before accusing your opposing counsel of lying. And he does. He doesn't sign like, "Thanks, Aaron." It's just, that's it. You guys are really something else. And then James Tuxbury, who is also representing the House defendants and Colin. "Aaron, I spoke with your partner Damon at length today about this. You said yesterday in open court that Colin Albert refused to appear for a deposition. That was demonstrably not true. Our email exchange confirms that Ms. Reed canceled the April 29th deposition. That misrepresentation has had real world impact as Colin and my other clients have faced an onslaught of online harassment, defamation, and intimidation sparked by your statements yesterday. Damon indicated that he would speak with you and get back to me with an explanation, if any, which I told him that I would listen to, and I remain willing to do so. Jim." Did you find any answers, babe?
Yes and no.
Okay.
So, this was an issue that was actually litigated improperly a couple of years ago in Florida. I know, right? In Florida getting something fucking wrong. And it seems it might have been overturned. But when you generally go by the rule of where the recording device is located.
Yeah.
So if the recording device is located in a one-party state,
Yeah.
the two-party, the other state, they could possibly try to sue you for civil damages, but it can't be made criminal.
It's not like it's not considered wiretapping, which is
Well,
what
that's
it's.
the thing. When you violate a
Right.
two-party consent, it is considered wiretapping.
That's what I'm saying.
But federally, the United States as a whole, on the federal law, is one party. Right?
Oh.
Two-party only exists in certain states. So if you call from the one party, again, they can sue you civilly,
Mhm.
right? Now, if you, as the person in the two-party state, admit to criminal wrongdoing over the phone, right? The evidence can be used federally. It's still undecided on whether it can be used statewide.
Well, that makes sense.
I
know it's confusing, but that makes pretty much sense. But okay. All right. So when did Jim send that one? I'm sorry. He sent that at 5:01 a.m. So this is all happening within like a half hour. So then at 6:25 on June 4th p.m., Aaron writes back, "Jim, Damon did not leave your conversation with any understanding of what misrepresentation you were referring to. I don't believe I misrepresented anything. But now that you've identified to me what you claim to be inaccurate, I am willing to review the recording of the status conference and evaluate whether I think that I misspoke. If so, I would, of course, correct the record." Half-assed fashion says, "Thank you for your service, Mr. Feet." He's useful sometimes. He's useful a lot. However, as you know, there were two ways for you and your firm to handle your concern. You could have sent a simple email to me, the lawyer you believe misspoke, identifying it and asking me to correct it. Instead, your firm elected the first contact with me regarding this issue to be a threat of sanctions and allegations of an ethical violation, still without any explanation. I take it from your unnecessary and discourteous aggression that you stand by every word you've said and written in this case. So we'll follow up with you later regarding multiple statements in your recent reply in the federal case and your defamation complaint that are demonstrably not true. Oh, we were right, Buffy. Those are going to be so spicy. The spiciness continues. Ooh. I'll let you know by Tuesday morning whether I believe any of my statements at the status conference warrant clarification. Thanks, Aaron. After he After he sent that, he was standing up at his desk, like, "Whoa, yeah, ooh, all right, spicy." Then June 4th, same day, 7:13 p.m. About an hour later, uh, Jim messages Aaron back. Aaron, I do not want to play a game of telephone. I raised these concerns in detail with Damon after the meeting, and he indicated that he will be the person we will discuss on this issue. That is why Kieran's email was directly to Damon. We spoke for a while, and I spoke in detail about our concerns regarding the specific statement, even telling him about the real world consequences of your misstatement. He told me that from his perspective, there was no intent to misrepresent, and that he represented to me he would look into it and get back to me. If he is telling you something different, that is disappointing, but I will await to hear from him directly before I assume there is an issue. So, not the person that you actually have an issue with. Okay, got it. From our perspective, the statement you made had no defense or basis in fact, but as a professional courtesy to Damon, I told him I told him would be willing to hear what he learned talking to you. So they're like not even wanting to talk to Rosenberg. Ooh, wonder what happened in the other cases to where they just now are like, fuck you, Rosenberg. I'm only dealing with Damon. Interesting. So messy. Everything is so messy. Our deadline to oppose the motion to compel is tomorrow. So if you will not agree to a corrective filing or give a valid explanation for you said, we will be forced to cross move for sanctions. There is no other time given the deadline on your motion to compel. Indeed, that is the procedure Defendant Reed followed in seeking sanctions in connection with plaintiff's motion regarding Ms. Reed's phone. The statement is very short and the issue is very clear, documented by an email correspondence that reflects that Colin did not refuse to appear for a deposition. Damon, this is bolded in Damon's name. Damon, as we discussed this morning, please get back to me tomorrow so we can discuss further and see if we are able to reach an agreement on this issue prior to our filing deadline. Best, Jim. He doesn't want anything to do with Aaron. um, okay, so then Aaron emails back 7:27. 20 minutes later, Jim, are you saying that you are accusing me of lying to the court and are now refusing to speak to me about it, insisting instead that you speak to my partner in some silly attempt to suggest that you are going over my head? Even considering your tactics thus far, this is an incredible level of unprofessionalism. Oh, these are so good. As you know, Mr. Albert refused to produce documents, then refused to provide additional availability, then out of the blue claimed he would be unavailable for the entire of our remaining discovery period, save for 2 or 3 days, without any explanation. Then, within hours of you sending that email, the plaintiffs improperly noticed a deposition on a date you knew our office was unavailable. And for the first time, your office claimed that our subpoena was somehow invalid or expired. So I do think that your client, through you and your firm, certainly played games to avoid the deposition. However, I've told you that I will evaluate the exact wording I used and let you know whether I think it needs clarification. But your colleague first identified this issue to me, the attorney you are attacking, at 5 p.m. today, when you already knew I was out of the office. So I'll do so early next week, as I said. If you're intent on attacking your opposing counsel as a perceived means to further your case, we'll respond as necessary. Oh, Aaron is here. So then 15 minutes later, 7:44 p.m., James, so about 30 minutes later, Tuxbury messages him and everyone else back. I can't imagine being all the other lawyers who are CC'd in this being like, this is amazing. You know, there was a group chat somewhere. So sassy. Haven't seen Mrs. this bitchy since Burr and Hamilton. Right? Oh, see, this is why that sometimes the best stuff is always found in the documents, right? So Tuxbury, and there, this is in Colin's side's exhibits that they put this in. It doesn't actually make them look very good, in my opinion, but okay. Aaron, no one is going over your head. I had a meet and confer with Damon on this, and that seems the appropriate route. I raised it with specificity that the exact phrases we had concerns with at 10:30 a.m. today, less than 24 hours after the statements were made. Again, our position is clear. It was an unequivocal misrepresentation to say that Colin Albert had refused to appear for a deposition. That statement has sparked substantial and vicious social media backlash. Indeed, the court today seemed to understand what I was talking about when I tried to raise it this morning. The court directed me to raise any issues through a motion. The opposition is due tomorrow, so I have conferred with your colleague this morning, discussing with him our concerns and desire redress. I am awaiting the response he represented to me he would make. It is Defendant Reed that has created this schedule with tomorrow's deadline. There's no need for a back and forth on this. I will wait for Damon's promised response regarding the statements made at yesterday's hearing, but we have a deadline tomorrow, as you know, Jim. Oh, wow. So then the next morning, Friday, June 5th at 6:12 a.m., Jim, this is from Aaron to Jim. Jim, I listened to the audio of the status conference, and I think that my single statement that Colin, quote, refused to appear was somewhat inartful in context. And I'm willing to clarify that for the court by letter on Monday. Again, had you simply pointed the specific concern out to me, the lawyer you are histrionically accusing of lying in the court in the first place, we could have avoided a lot of wasted time and energy. As you are well aware, when a judge asks specific questions about many matters at once, sometimes lawyers misspeak. The professional course to take when you believe a correction is warranted is to point it out to the lawyer in question and ask for the correction. But I know that's not how you and your team operate, and will certainly keep it in mind in the future. You'll receive a copy of my letter on Monday. Best, Aaron. This time he signs it off. He did not sign off some of the other ones. Best, Aaron. Oh man, what goes down in these other cases must be good. All right. So then at 9:09 a.m., June 5th, Jim messages Aaron back. Aaron, I'm going to avoid responding to your personal criticisms of me and our team. Given the grievous impact these types of misstatements have had on our clients in the past, especially when unaddressed, we have no choice but to take them very seriously and to avail ourselves of the protections that the rules provide. We appreciate your willingness to correct the record on this issue. We will review your proposed filing with the court on Monday, and hopefully we can reach an agreement. In light of that, here is what I would propose. Our opposition to the motion to compel is due today and would have to include our cross motion for sanctions. Given your proposal, it would make sense for us to hold off on serving our opposition and any cross motion until Tuesday, so we can see if we can reach an agreement as to the appropriate remedy. In terms of the procedure, given the severity of the issue, I raised this issue with Miss Reed's counsel at the hearing yesterday morning, who was Damon. He indicated that he would address this issue with me on behalf of Miss Reed. That is all. Best Jim. Oh my gosh. Liza says, this exchange reminds me of exchanges I've seen on the mommy group. Like these guys are lawyers and they are being so it's hilarious. Oh my God. I cannot wait to read. Right? They do not mean best. That is not what that means at all. What has gone down in these other trials and filings, y'all? Ham's gonna be on fire then. I already knew based on what I was looking at as I was like organizing stuff that it was going to be crazy, but woo, can't wait to get there. All right. So that is all. Jam. Well, guess what? Aaron messages I'm back at 10:58 a.m. Jim, it's easy to pretend to take the high road after shooting from the hip with attacks on your opposing counsel's character and integrity. I agree to extend your 9A deadline to Tuesday. You can review what I send to the court and decide whether you plan to continue baselessly calling me a liar to further your own ends. Aaron, no best. No best for Jim there. Mm-mm. So those are the emails. That apparently, they thought made the defense team seem bad, but that does seem kinda childish. Why would you not just if your problem's with Aaron, why don't you, email with Aaron? I'm just saying. Why is my camera always turning? There we go. Alright, and then we do have some social media posts, apparently. I'm sure they're great. And I will bring these back up on for you guys so that way you can finally look at something besides my face. Um All right. So this is Boozy Beauty. Wait, isn't that the TikToker you follow above? I think so. Boozy Beauty. That sounds really familiar. I don't have social media, so I had to hear from it from one of you guys. According to today's O'Keefe v. Reed Canton Bars hearing, Karen Reed's attorneys are preparing motions to compel against several witnesses, but the situation involving Colin Albert stood out. Reed's attorney, Aaron Rosenberg, told the court that Brian Albert and Nicole Albert, apparently they can't be bothered to show more, I guess, but there's a picture of Colin with Brian. Yeah. Oh, she's also on YouTube too. I did not, maybe I forgot you said that. I know you talk about her TikTok, but oh, okay. Well, she showed up in a motion. Between the lawyers and the judge, the combination of characters in this case is crazy. Yes. Oh, man. Oh, please don't let it be the same time as Murdoch. Please let it start in June. Please and thank you. Because, oh, wow. Oh, there's a link for her channel, guys, if you want to go subscribe to Boozy Beauty. Ew. Buff is a big fan. Sorry, I didn't even know she had a YouTube channel, so I guess I'll be checking her out and subscribing later as well. All right, so there's a picture of Colin with Brian Albert, who always looks like he has like guy liner on. Isris says, "Oh God, oh good. Colin is going to learn how to murder more efficiently." Well, that's the internet's opinion. I don't know what to tell you. Here is a post from Turtleboy, Dr. Turtleboy, aka Aiden Kearney. Says Colin Albert has suddenly decided to join the army and will be unavailable to give a deposition in the Karen Reed lawsuit. Hopefully, our country is a little safer now that we are being defended by a person who testified that an award-winning journalist speaking into a window. Why aren't they showing more? If you're going to put these in as exhibits, show more. I'm about to ban you, Amos. I'm gonna do it. You're gonna time out. Does the army, Susan says, does the army know that he was in the house? Sir Earl of the Grey says dodging your deposition to get sent to war. Good option, Colin. That doesn't make you and your family look ridiculously guilty. P.S. Everyone knows you're murderers based on your own testimonies. At Dr. Turtleboy has nothing to do with that. Sue me. I mean, their testimonies are very odd. All right. None of them won me over. They were some of the weirdest testimonies I've ever heard. Doesn't make any sense at all. Cat Ryan at Cat Questions All, love that handle, sharing now Colin Albert can kill legally as they're sharing a post from Big Daddy D. Because I know when somebody's Big Daddy D, take them very seriously. Guess who is fleeing in order to not be deposed and answer the tough questions? Just because you join the service, it won't shield you from prison. Bang, bang. That doesn't look like him in that football picture, but. All right. Boston Brandy says, Colin quickly enlisted. Will they get to him before he jets off? It's amazing how some people can dodge a deposition with Olympic-style agility, then suddenly discover a calling to serve with sworn testimony is on the horizon. And they share a TikTok clip from the June 3rd hearing. Susie says, oh, Colin, refusing to appear. Why, Colin? Then saying you are only available for 7 days and that's it. What's up, Colin? Bang, bang. Refuse to produce documents. Then we got another one from Boozy Beauty here. According to today's O'Keefe v. Reed Canton Bar's hearing, Karen Reed's attorneys are preparing motions to compel against several witnesses, but the situation involving Colin Albert stood out. Reed's attorney, Aaron Rosenberg, told the court, oh, we already read that. That was hers. I'm sorry. But it has a response from Sir Thomas Awade. Nothing fishy about that timing at all. The McGowers are hands down the dumbest yet most transparent criminals of all. First, they tried to hide little Collie Bear and now force him to enlist and ship him off to boot camp. Can't help but feel a little sorry for this now man-child. Jesus. Ooh, they are tough over there, aren't they? Oh, she does lives over on there. Nice. Okay. Well, friends, this is what I'm going to stop for today because there's another one that's filed on the same day. That's 4 pages for us to read. But then after that, we have 2 hearings. So I'm going to save the 4 pages just to put us in the mood and the environment again, get us riled up before we watch these hearings tomorrow. I don't think, Bob, how you scheduled the thing for tomorrow? I'm thinking we're going to go on a half hour earlier at like 1:30, just so we can fit in the motion to compel hearings and that reading. So I want to make sure we can get that in there. So can you schedule that for 1:30 Eastern? Please and thank you. I don't think you're around tomorrow afternoon though, right? But I can come on and do that, and we'll get through those, and then maybe Thursday. Yes, 1:30 Eastern. Please and thank you. And then I guess we're gonna have to watch Colin's testimony. We're gonna have to. We're gonna have to do that on Thursday. So, uh, okay. I don't know why my headphones are being super weird today. Anyway, so I'll be back tomorrow, 1:30 Eastern time, to talk more Colin. I'll be online for a little while tomorrow afternoon, like I was today. Okay, I couldn't remember what you said before we went into the stream. I was like, I'm pretty sure she said something. So we'll start early tomorrow, and I'll let the team know, or if somebody wants to let the mods know, that will be well. Oh wait, this will just be on Couch Court, so never mind. But anyway, well, that's where I'm going to leave you today, friends, because I am starving. It is now my feeding time, and I'm a hungry llama. So we will do that tomorrow. Very interesting readings Oh man, that's good stuff right there. Can't wait. But anyway, so that's all I have for you. Please like, subscribe, hit the notification bell if you haven't already. We'd really appreciate it. It helps get our little channel noticed and on our way for you guys to be able to get like memberships and super chats and I think jewels and stuff. I don't know all the cool things you get, but we would like the cool things too. Um, but anyway, my friends, as always, until next time, go forth and be amazing. All right. All right. Bye, friends.